Okay, folks, it's 12:45. I think we will reconvene. We will now reconvene the adjudicatory hearing of the Massachusetts Gaming Commission on the suitability background check for Our Way Realty LLC. Before we go to the applicant, do we have any determination on the transcript or anything else to add?
Yes, Mr. Chairman. What we agreed is that the applicant's counsel is going to review a copy of the transcript, which they, of course, have. They'll suggest appropriate redactions, if any, get the document to us. We'll review the redactions and then provide it to the commission as soon as we can. It's unlikely to happen today, I think, just given the fact that they're here and we're here, but we will get it into the commission as soon as we can.
What's the consequence of that relative to our ability to use it at this meeting?
In effect, there's a stipulation between council that this will be admitted under those circumstances, and we can simply take it and mark it as the next exhibit in the line of exhibits when we get it.
It would be exhibit number 6.
And can we use it
Yes.
in today's conversation?
In your
In today's
closed deliberation.
Oh, I know we can use it in the deliberation. Can we use it now in the conversation? If Commissioner Cameron referred to it, that she thought that was an important document.
What I had initially intended to do, because the document was not in evidence, we hadn't marked it, was to provide the applicant's witnesses, and I've done that, with the 1 or 2 pages of that sworn testimony that I was going to allude to, but I was not going to, I had not intended until today, in the discussion that we've had today, to put the entire document into evidence. I think that I will make reference to it in connection with my questioning on a couple of occasions, but I was not intending to use it extensively in cross-examination. I don't believe Mr. Richland had any intention to use it either.
I think the position, if I could just have a moment to confer with Mr. Grogan
Sure.
on this.
Okay.
The position of the applicant is that we will go through the process that Mr. Mackey described, but to the extent any commissioner wants to make use of that in today's hearing, we have no objection. We understand there's a risk that we may later seek to redact that information, but I accept that that would effectively be a waiver, and we accept the consequences of that waiver.
Okay. Okay, thank you.
No concern about that.
Fine.
I do have one point of correction. I spoke to Mr. Ross out in the hallway, and he indicated that made an error. He has been involved in the parimutuel racing industry since 1956. I apologize for aging more than beyond his years. The 1941 day was the day they'd taken over the racetrack, so I just want to clarify that for the record out of consideration.
I was impressed by your good health, Mr. Ross. Okay, we now pass the baton to the applicant to make the presentation and their counsel on behalf of Our Way.
Good afternoon, Chairman Crosby, Commissioners. By way of introduction, my name is John Grogan. I am the president of Our Way Realty, and on behalf of Our Way, I want to thank the Commission for the opportunity to be heard in this adjudicatory hearing concerning the suitability of Our Way, or Plain Ridge Racecourse, as we're more commonly known. We understand that we need to establish by clear and convincing evidence our affirmative qualification for licensure, and really that is our hope and intent to do that today. We will, I guess as you well know, we are well and ably represented by Foley Hoeg, here with Dean Richland and Kevin Conroy, and I will testify in a narrative form, and perhaps with the help of Mr. Richland to ask questions to the extent that I omit some information. I want to thank the IEB and the Michael and Carol investigation team for their very fair and detailed investigation, and in fact it was that very investigation that led to the particular set of individuals that you're going to see here today. We would also stipulate to the accuracy of the report and don't question the findings of fact within it. I guess, however, we may differ on a few contractual and tax conclusions from them, but other than that, we not only don't question that, but actually applaud them for the work that was done. By way of my background, you heard a little bit about it this morning. I live in Westwood, Massachusetts. I am the president of RWay, and I was appointed in that position on April 3rd. I have an undergraduate degree in biochemistry from Harvard College. I have an MBA from Harvard Business School. I was an investment banker for 25 years, starting in New York and then in Boston. In my current position, I began working for Plainridge in 2009 as a consultant to help develop both the business and financial model for their Plainridge's planned expansion into casino gaming. I was also the point of contact for the Phase 1 process, so all of that information sort of went through me. And as an aside, we sort of view the regulatory process as a fundamental business process. This was not something that was outsourced to council, but sort of kept inside as a fundamental business process because of how we view regulation. And I was appointed the president on April 3rd upon the resignation of the former president. As I'll talk about later, Stan Fulton is our CEO. He took the position of CEO on July 17th, and I report directly to Stan. And I have dotted line responsibility to Al Ross, who is the managing member, probably more commonly thought of as the chairman of our company. As the president, the general manager and director of racing reports to me, as well as director of operations, director of customer service, and until Tuesday, the financial officer. Just to touch a little bit about the history of Plainridge, and I know, again, Director Wells covered a little bit of that this morning. We started this 15 years ago. And the business was started 15 years ago with 15 local investors whose vision really was to revive horse racing in the Commonwealth and specifically in Norfolk County. Gary Piantowski was the founder of the company, and he had a vision for horse racing in the Commonwealth, himself being a horse racing owner. And he found two principal investors, if we sort of skip through a little bit of the timeline, how that all happened, but found two investors in Mr. Ross and Mr. Fulton to support his vision. And through a series of transactions as described in the report, they became both the largest shareholders and the largest creditors and lenders to the company. Notwithstanding the size of the investment that they had in the company, they were passive investors. They had no oversight, no executive functions, and they did not have, want, or feel necessary any oversight, responsibilities, or authority. And they had trust, and the trust in the former president was complete. We currently employ 140 people directly and indirectly support hundreds of people through racing and its reach throughout the Commonwealth. And by interestingly enough, racing, there are 72 standard-bred horse farms in the Commonwealth, in fact 4 in the town of Plainville. As Director Wells mentioned, we are funded entirely by our members or shareholders, and regardless of the nature of whether we call that a debt or equity, it is their contributions each year that keep the track running. The track, as described, loses money. It has, and they have continued to support that business endeavor. And really, they were content in a passive investment really prior to the gaming application, which certainly changed the nature of our business and as we are here today, changed the nature of oversight. What I want to do is talk about the event, and much of my conversation today will focus on what the IEB concerns regarding internal controls and governance. I know there's a lot in the report. We're happy to address that at any point, but most of my comments now will be around internal controls and governance and things that both led up to that, what we're presently doing and what we will do in the future. And again, all the events started with the IEB interview with Mr. Fulton in Nevada. I was in fact present for that interview because at the time I was a consultant to the company and not a qualifier. And in that interview through Mike Bohr began a series of questions around the money room withdrawals, the frequency, the methodology were presented in great detail to Mr. Fulton, and that began, as reported in the IEB report, a series of discussions about those issues, the lack of controls that led to that, the lack of oversight that led to that, and resulted in the resignation of Mr. Piantowski from the company. Upon that resignation, he surrendered all his offices in Anchor Partners, in Our Way, sold his stock in the company to Mr. Fulton and Mr. Ross, and other than a separation agreement that provided for some salary continuation for a point in time, he has no contact, influence, or involvement in the company right now. As the report points out, Our Way has a historic lack of effective governance and controls. Again, the report is replete with incidences that are a result of those things. I myself learned about a number of them from reading the report, and it was clear that there was behaviors that were questionable and should not have happened. And I acknowledge those deficiencies, and we don't dispute them. How'd this all happen? My analysis of how this happened is from 2007 onward, the president and the manager were the same. And therefore, that person had total control of the organization. There was no oversight, and there was no accountability for the actions of that person. Also, as Director Wells mentioned, there were no written policies or procedures within the company. The result of that is that employees were unaware of what was expected of them, and also what to do if something were wrong. And in fact, as Director Wells mentioned, managers were in fact told not to write things down. What comes with that also was sort of a deference to senior management, and what happened is you created a culture that people were unwilling to confront issues of concern. They did not raise issues to the investors, and fear of losing their jobs limited their actions. Coupled with that, there was a lack of engagement and attention by the members. They were willing to accept either the information they received or willing not to accept information that they should have had. So there was an inadequate flow of information to the members. Having said all that, there were certain things the company was doing correctly. If we make the distinction between internal controls and financial accounting, Our Way's financial accounting was appropriate. The experience, as we talked about, in terms of the people we have in the money room, in the financial side, they had an established pattern of practice. It was not written down, but you had people who had been doing this for a very long time, and those established practices were able to track all of the withdrawals that were discussed. They were tracked, documented, and reported both to the auditors, and again, as we'll talk in a minute, in that letter from the auditors to Mr. Fulton and Mr. Ross in 2012. And so the auditors did bring the information regarding that to the attention of the majority owners. I was appointed to this position on April 3rd, around 5 o'clock at night. And at 8 o'clock that night, I got a call from the IEB investigator asking me to come and give testimony to the IEB on April 4th. So the things that have happened since then, I was appointed president. I am subject to a written agreement, not to be confused with an employment agreement, but a written agreement that defines my duties and my authority. And part of that is an agreement not to self-deal or to benefit financially from my position other than my salary. We have also separated the roles of president and manager. So Al Ross is the chairman, and again, as I mentioned, Stan Fulton is now the CEO. And so we have that role of oversight. The other thing that happened on April, or subsequent to April 3rd, was matrix reporting of the financial officer. I had met with Mr. Peterson and Mr. Ross to make sure that the lines of communication from the financial officer to the chairman was open, and that if there are any questions regarding actions the company was taking, I was taking, Mr. Peterson should feel totally comfortable to go directly to the chairman. We also created a board of advisors with an independent director, and I will talk about them in just a minute. But all this was part of a plan. So when I testified to the IEB on April 4th, I had both a one-week plan and a 1-month plan about what would happen. And Director Wells outlined many of those things that were being taken. That 1-week plan were some very simple things that I know I could do. We could end the money room withdrawals, that they would not happen. There were certain patterns of behavior around the tellers that we wanted to correct. And those were the sort of immediate things that we could change. We had that 1-month plan, and part of that, part of that 1-week plan was the matrix reporting for the financial officer, so we wanted to make sure that we corrected those lines of communications, those questions. We wanted to end the immediate questionable practices. And then we also created a board of advisors with an independent director. What I would, if I can, I'd like to talk about who those members of our board are. You've heard Director Wells describe Stan Fulton. Stan has a long and distinguished career in the gaming equipment business, one of the original creators of Wheel of Fortune, the most successful slot machine perhaps ever, and was also part owner of the Tito Ticket In, Ticket Out intellectual property patents are all as a result of Stan. He was the CEO of Anchor Gaming, and aside from it's a gaming equipment business, it was also a casino operator. And as described, Anchor was sold to IGT in early 2000, and he now owns Sunland Park and Casino in Sunland. He's had numerous gaming licenses, and his career in the gaming business is outstanding. So Stan is our CEO. He's actively now involved in what we're doing, and he is also provided, beside from being our largest creditor, as Director Wells mentioned, he is also providing the financing commitment for our project if we were to receive the Category 2 license. And so that is a substantial commitment and a measure of his faith in our ability, and I think the people who are at the company today. You'll hear from Mr. Fulton a little later today. Al Ross, again, distinguished career in the parimutuel business. Interestingly enough, he at one point owned Taunton Greyhound Park. He owned Twin River. He had an ownership interest in Suffolk Downs. Interesting in light of the competitive market for licenses here in the Commonwealth. Again, as the chairman, he's responsible and leads our board of advisors. And I'll say our board is composed of three inside members. So Mr. Fulton, Mr. Ross, and Mr. Levine. Mark Levine is a member of our LLC, a small minority member. He is a partner in Core Capital, a venture capital firm in Washington, D.C. He's an experienced venture capitalist, has sat on over 50 boards, both public, private, nonprofit, and currently sits on 9 boards right now, not including Our Way. So as we think of Mr. Levine, sort of an experienced professional director who understands what's required of a company and the controls and governance necessary. Our independent advisor is a man by the name of Shore Berman. Shore Berman was the president of Memorial Drive Trust. Memorial Drive Trust was the pension fund of Arthur D. Little and has an extensive venture capital background, has sat on numerous boards, much like Mr. Levine, is a professional director. He brings to the board not only that expertise, but also is an independent, has no ownership, and is an independent sort of financial director. We did that in part because in our 1-month plan, we were going to form a audit subcommittee of our board of advisors. Traditionally, that's done because of the heavy lifting that's required of the audit committee. Right now, because of as we begin to introduce the board to the things that we're doing, we don't have a subcommittee. The board is involved in every aspect of that. And in fact, we formed this, starting on April 3rd, the board met on the end of the month and reviewed our financials with our auditor and the draft statements, and that was done by the whole board rather than any subcommittee thereof. So that is our board of advisors. In fact, we met in April to review that. We also met earlier this month so to get the sense of what we do. This is the board package that went out, and it was a discussion that was both strategic and operating, reviews of budgets, where we were, discussing where we were with the IEB, issues around our host community agreement. We have talked about our internal control plans with the board and gone through operating budgets in both our, as we characterize them, both on our operating business and also the budgets that we have regarding our gaming application. We have also begun a process of written policies and procedures, and part of that is an attempt to create a culture based around rules and hierarchy, as opposed to a business ruled by exception. So our money room and teller policies have been provided to the IEB, and all departments are now in the process of doing their own written policies and procedures, nearing completion on many of them. And as described, we're in the process of our employee handbook and making clear so that our employers will understand what's expected of them. Beyond creating policies and procedures, what's necessary is also to create a system both to implement, monitor, enforce those policies. Aside from writing them down, you have to make sure they are followed, and you also have to have consequences for the lack of follow-through on that. So we are both creating those and then creating a system to make sure that we continue to implement them. And then we're also defining limits of authority within the organization at the operating level, signature authority, whether it's checks, contracts, and the like. is being made clear to everybody within the company. Perhaps the greatest change that I'll say we are doing is creating a culture that's based on integrity, accountability, and responsibility. That starts with both at a department manager level and at an employee level to take responsibility for their actions rather than accepting being told to do things. I am endeavoring to create an environment where people are encouraged to ask questions. It's based upon the idea that we're going to have a reasoned basis for why we do what we do. And if we can't answer that, we'll figure it out. And we, in fact, want questions coming from why do we do things. Recently I got an email from an employee of the company asking me why we were doing certain things. In her mind, what we were doing didn't seem to make sense. And I've said everything we do will make sense if you understood what was sort of encompassed within that decision. And as a result of that, we actually changed certain operating practices of the company so that we are creating that environment. What's also part of that is creating a culture that's accepting of mistakes. I would say heretofore, there was concern about making mistakes and the ramifications of making mistakes. I want to make sure that as an organization, we accept mistakes, learn from mistakes. I'd say the only mistake that we could make is not learning from the mistakes that we do make. We are a human organization. We will make mistakes. And I want to make sure everybody understands that that is okay. In our commitment to our culture of oversight and compliance, we understand the significance of the license we're seeking, and a gaming license is a public trust. And as a result, we know we will be subject to regular and ongoing scrutiny, and we welcome that scrutiny. We've begun that process in April, and we're building a company that will be worthy, that we hope and believe will be worthy of such trust. And as we think about that, this culture of integrity, accountability, and responsibility starts with our board of advisors. The board is now actively engaged. Each and every member has put their personal reputation on the line to join this company. I know what they will demand of me, and I know what I will require from the people that work there. We will always do the right thing, and integrity and accountability and responsibility is the cornerstone of the company we are looking to build. So those are my general comments. I know you will have specific questions about things that have happened, but I wanted to sort of put this in a framework of internal controls and governance and the things that we are doing and we endeavor to do.
Mr. Chairman, then if I could just ask a few questions
Sure.
To elicit some additional information from Mr. Grogan. Mr. Grogan, in your testimony to the IAB investigators, I think you described the reclassification of the advances to the former president as an accommodation, and I think the report also recognizes that statement. Could you tell the commissioners what you meant by that?
The understanding was that you saw the accountant characterized, the withdrawals were characterized in the financial statement as in a due to, due from, so they were characterized as a form of a loan. And at the end of the year, the question is what to do with that loan. And so it was an understanding that would be treated as a capital withdrawal, again, as an accommodation to the president at the time.
And again, when you say accommodation, what did you mean by the word?
It was an acknowledgement of how to characterize that. So rather than force that as a loan to be repaid, it was treated as a capital withdrawal for him.
And as a result, did you have any understanding as to whether he would be required then to repay that amount?
It was, yes, it was treated as part of his capital account, and so, yes.
All right, now.
Yes, he would repay it?
Again, it was characterized as a capital account that would eventually get settled as positive amounts flowed through flowed through into the capital account from an LLC accounting basis.
So did he pay taxes on that? It was not a K-1 distribution?
It was a capital account withdrawal, so I don't believe that taxes were paid on that withdrawal because that was not a taxable event.
And it wasn't a taxable event, why?
That I can't answer.
Well, did the entity have a profit?
The entity did not have a profit.
Okay. And was the distribution, was it categorized as a distribution even though no one else was receiving such distributions?
Yes, it was.
Okay. So he was the only one
Receiving a distribution.
receiving a distribution?
Correct.
And then to follow up on the chairman's question, if the former president had remained in office and profits had flowed to the members, if you're able to do so, what would have been the consequence of this distribution to the former president?
I understand. It would have offset, he would have not gotten profits distributed up to the extent that he'd already had, in effect, an advance payment.
That's correct.
I understand.
That's right. Good.
Thank you.
Can we follow up on that now?
Yes, of course you can.
Who characterized this as a distribution? And who knew about this distribution?
The accountants characterized this as a distribution, so at the end of the
The
year.
accountant didn't know how to characterize it. He was trying to figure out what he should do.
But ultimately, I think that was their determination that it was a.
Who knew about these distributions?
Well, as you see from, there is that letter, so in a 2012 timeframe,
Which Mr. Fulton says he didn't know about. And you didn't know about, Mr. Grogan, is that accurate?
oh, that is accurate,
So you were surprised to find this out on April 4th.
absolutely.
So the word distribution is, try to give us a word that can account for this behavior?
Well, no, it was,
Well, again, I would want to distinguish between sort of accounting treatment and behavior, so perhaps if, could you
You want me to
refine the
rephrase that question?
Refine, yeah.
Is this the way the accountant tried to explain the taking of money from the money room by calling it a distribution?
I'm not sure I'd say accountants are trying to explain. So now you have something that showed up on the balance sheet as a due to, due from, and now you sit there and say, how are we going to characterize that as it sits there?
Okay, so he was trying to figure out how to characterize it. Is that accurate?
Account for, I mean, again, I'll say purely account for.
If I could bring to the Commission's attention the IEB's Exhibit Number 5, and although I would just note that this document refers to attachments, I don't think we've seen the attachments. We've just seen the letter, and I think, as I understand it, based on the report, it was produced by the auditor to the IEB. But if I could draw your attention to this document, Mr. Grogan, and simply ask for you to again explain how the auditor treated what he calls advances from the moment the money left the money room, went into the former president's hand, and was held for at least a year and longer. How did the auditor treatment proceed? In other words, how did he consider it initially, and how did he consider it later on? And what were the choices that he laid out for the members?
Again, so I'll read from this letter that said, the former president received advances from the company, and the advances were charged as distribution as a capital account. For 2011, the advances totaled X made up of various transactions, as you can see from the attached summary. For financial statement and tax purposes, it's not proper to continue to reflect this amount as a due from receivable for several reasons too lengthy to summarize in a letter to you. As such, the appropriate amounts of the receivable should either be reclassified as compensation or adjusted through his capital account.
And then I would direct your attention to the second to last sentence, and if you would read that to the commissioners. Second to last sentence.
Unless otherwise indicated, we will assume you prefer the adjustments of the advances to be reclassified to his capital account and not as compensation.
And
So can
Please. No, I'm not, but
Let-
please continue. I'll ask a question after you, Commissioner.
So if I read this letter correctly, the reclassification to the capital account meant that there was a negative balance in the capital account, right?
That's correct.
That negative balance, had he remained a member of the corporation or the company, would have been offset by gains in the future.
Correct.
But he didn't remain a member of the company. So there will be no gains attributable to him in the future to offset that negative balance, right?
You're right, he is no
Right.
longer a member.
Right. So the net effect of this is that when the company learned of these unauthorized transactions, they created a debit in his capital account, then allowed him to withdraw, thus converting the debit into a authorization to keep the money he had not been authorized to withdraw. That's how that all winds up, right?
Yes.
And in addition to that, gave him the money that was the value of his shares of stock, and gave him a salary severance stretching over a period of years.
That's correct.
And that was the consequence of learning of the unauthorized withdrawals of substantial sums of money over a several-year period.
Separation from the company, yes.
Yes, sir.
Yeah.
Why? You were involved in that,
Mhm.
Mr. Fulton was involved in that,
Mhm.
Mr. Ross was involved in that.
Mhm.
Why?
I think there was an acknowledgement of what, we'll back up, his stock was purchased. There was, again, as a separation agreement, I think part of that was an acknowledgement of what he had done to advance what he had done for the company over the prior 14 years. And part of that was an acknowledgement of that effort.
I asked that question because there is, and you've spelled it out here, a strong suggestion that this is now going to be a different company from the company that is described in the IEB report. But the principles, the three principles of this new company were three people who approved of this way of dealing with what in many other circumstances would have had a very different outcome. And so I am trying to understand why it didn't have a very different kind of outcome here.
If you're looking to establish a principles of integrity, accountability, and honesty, or whatever your three principles were, is this indicative of that?
How is this consistent with that?
Again, the withdrawals that were taken were financially, again, pattern of practice that, if known, would have not occurred. I think the separation and how that was done, I don't think that repurchasing his shares and severing him sort of would question, would be a practice that would question again, the integrity of the people involved in that decision. So when you say, is that pattern?
I'm not suggesting a lack of integrity on the part of the people who authorized it. I'm simply wondering how that method of treating a serious departure from normal business practices, to say the least, how treating that in the fashion that the three future leaders of the company chose to treat it sends a signal to this commission that the future is, in fact, going to be different.
When you say the future will be different,
That this kind of conduct that significant irregularities in the company will not occur, and that controls are in place to assure that they don't occur. How does this method of dealing with that, let's use the right word, defalcation, convince this commission that that's not going to occur in the future?
Again, two aspects of that, Commissioner McHugh. One is that what we understood at that time is in fact different from the IEB report that was done. The involvement of the individuals at that time and what they knew was limited to this letter. And those withdrawals and capital account withdrawals and that, again, the frequency and the practice wasn't perfectly clear. There was a problem. They understood the problem in a larger context as opposed to the specific methodology of that, because this letter talks about those advances, and it doesn't talk about where those advances were coming from. And so this started that conversation. And so that pattern so what they knew and how they solved that, I don't think relates to future action. So that if this were to happen tomorrow by me, would they do the same thing? The answer is absolutely not.
But okay, Mr. Grogan, I hear you as of February 7th, but the withdrawal agreement and the permission to withdraw and the circumstances under which the withdrawal was accompanied, and the financial considerations with which the withdrawal was accompanied, came a month later, or 3 weeks later, after all the circumstances were, but 2 months later, after all the circumstances were known, on April 3rd.
I think that this letter was brought to the attention in the end of March.
But
regardless of the
Mr.
date.
Fulton Ross and Mr. Potowski signed it. I see, the letter's dated April 7.
The
2012.
That was 2012.
Right.
So this letter, again, began a series of conversations.
I'm sorry.
When presented, in fact, by Mr. Bohr to Mr. Fulton in the end of March in 2013.
May I follow
Right,
up with some
all right.
questions?
All right, I hear you.
Which I hope may be helpful to
Right.
your point as well. Mr. Grogan, at the point that management, you, Mr. Ross, and Mr. Fulton, were beginning to appreciate what the IAB was revealing by way of question, what value did you place in removing or reaching agreement with your former president as quickly as possible so that change could occur?
So, right, while that letter is dated in 2012, when that was brought and pointedly brought to Mr. Fulton. And as you see in his testimony, when presented with that, did not recall signing that document. But when faced with the questions, it was sort of very quickly determined what would be, it would be important to separate Mr. Piantowski from the company at that time.
And additionally, given, do you know whether, you're aware that both Mr. Ross and Mr. Fulton have confirmed that they did in fact sign this document?
I'm not aware of that, sir. Mr. Fulton said he did not recall, and if he did so, he was told to do it, and he was not aware of the actions to which that document speaks.
Commissioner Cameron, I think what I'm recalling in the report is upon the second interview, he acknowledged that was his signature.
Well, he said it may be his signature. He couldn't tell for sure. And if it was, he might have just been given that to sign.
Right. In any event, he didn't dispute that it was his signature.
But he wasn't sure either.
And
I think the validity of that document is in question.
well, Mr. Fulton will speak to that, but the question I wanted to ask Mr. Grogan was this, which is that did there appear to be at least some evidence that whether they appreciated the significance of their signatures or not, that the advances and the reclassification of the advances had been approved by the members?
I don't think there's evidence of that. I haven't seen it in what I've read.
I don't want to engage in argument at this point. I think that the letter itself is evidence of
A
that.
document that the principal does not remember signing and says he has no knowledge of what the document speaks to, which are these disbursements.
Well, let me move on then and ask this question. Part of what you were trying to do relative to the separation of Mr. Piantowski was to resolve all of his connections with our way. Is that right?
That is true.
And in terms of the period of negotiations, how much time elapsed between when management reached the decision that that he was not appropriate to continue in the position of president and, in fact, reaching agreement for his departure?
Very short, I would say, perhaps a week.
And in that week's time, it's true, is it not, that not just his role as an officer, but also his ownership of stock was resolved as well?
Mm-hmm. Correct.
Again, did urgency play some role, and the fact that this process was ongoing, that is, the process of the investigation and the consideration of suitability, play some role in how Arroway approached the negotiations with Mr. Piantowski?
Absolutely. I mean, it was important to do this and to do it quickly and to make that separation and to move forward. And so it was done. It was done to effect change as quickly as possible.
And getting back to Commissioner McHugh's question, what was the relationship between the complete separation of Mr. Piantowski from Arroway and your efforts to create a culture of integrity, accountability, and responsibility?
Sorry.
Yes, I'll ask again.
Okay.
I say, what was the relationship between the resolution of Mr. Piantowski's relationship to Arroway and your efforts to create a culture of integrity, accountability, and responsibility?
We wanted to separate that as quickly as we could to begin that path into a new direction. And so it was important to do it quickly and to make it clean and to move forward in a very different direction.
Is there any open dispute that you know of between you and between Arroway and the former president?
None.
Is there any threatened litigation that you know of between Arroway and the former president?
No.
Has there been any continuing communication from him to the organization since its departure in early April?
I've received a few emails from him asking some questions about some old tax matters, but it's very little communication.
If I could just follow up on, I think the direction that Commissioner McHugh was going, and it is, I think it's, at least as I hear it, I think it's an important point to make, that the gist of what Mr. Grogan is saying is, trust me, we are gonna fix this, and we are gonna establish a culture of integrity and responsibility and accountability going forward. One of the most powerful ways to establish a culture such as that is to hold people accountable who do inappropriate things, particularly when they're your friends, whom you like and have liked for a long time. And it appears here that the way it was handled was, after a series of at least inappropriate acts, and overseeing a system which was utterly bereft of the most normal kinds of controls and operating standards, that Mr. Piankowski was handled with kid gloves, with respect, with appreciation for his prior life and prior friendship, and I can appreciate that as a human being, but that does not strike me as a way to tell the rest of the people in your operation that you better follow the rules. What you've done here is take somebody who's didn't follow the rules and was treated pretty gracefully, seems to me.
If I could put that into a question, why didn't Arroway terminate his employment without an agreement? Why didn't it simply terminate him, put him out the door,
Right.
on the basis of what you had learned in the investigation?
What was important was to make that transition as cleanly and as smoothly, and as counsel is suggesting, protracted litigation with a former president would have been detrimental to the company. But I want to come back to two points that you made, Mr. Chairman. One is when you're saying, trust me, this is what we're doing. This is not an act of a single individual in terms of me, in terms of creating that culture. This is, it starts at our board and starts with the active involvement of the members, the two major shareholders, which weren't before. So this is not a trust me, we'll do this. This is being done by starting at the board and moving through. The second thing, saying that how the former president was treated in those negotiations, I think that he would not characterize them as you did. That conversations were extraordinarily difficult, and I don't think it would be characterized as trust and respect, regardless of the appearance. And I think the repurchase of the stock, which was done, and the salary continuation was a effective way for the separation to happen.
Okay, I think interrupted you in the middle of questions. Do you want to go ahead? Are you still in your follow-up?
Yes, I do have a few more.
Okay.
If I could proceed. Just to kind of finish up this topic of these withdrawals, in doing your analysis and based on what you learned through the investigation, did you come to some understanding as to what role, if any, Mr. Fulton and Mr. Ross played relative to either the approval, sanctioning, or reclassification of these withdrawals that Mr. Piankowski had taken?
Again, they were, as passive investors, they did not, weren't, to my knowledge, involved in all of those decisions. They were not part of that.
And did you come to some understanding as to why it appears that their signatures are on this document, that is Exhibit 5?
Again, it was presented for their signature, but what was explained to them, what it was, I don't know.
Now, I want to, at this time, show you what's been marked as Our Way Applicant Exhibit Number 1, and I believe this was part of our pre-hearing submission, and I believe the commission has this already, and if not, I'm happy to give you copies.
We don't not, right?
It's
Oh,
a
this-
one-page document that is labeled Governance and
Oh, yes,
Internal
yeah,
Control.
sorry.
And so I want to put that before you, Mr. Krogan, and ask you, do you recognize that document?
I do indeed.
And is this something you created?
Yes, it is.
And can you date that version of the document?
Absolutely. This would be dated post July 17th because it references Mr. Fulton as the CEO.
And were there earlier versions of this document?
There was the basis of this was what I called my 1 week, 1 month plan that I presented to the IEB on April 4th. It's evolved slightly since then. It has some subsequent information regarding our first board of advisors, but it is along the lines of my 1 month plan.
And what was the purpose of creating this document?
Well, it was done for me. It was done by me, sort of saying, here was our plan. So when I got the job, what was I going to do? What was I going to do instantly? What was I going to do in a longer-term basis in terms of address the issues of oversight and controls, which we knew were lacking.
And does this version of the document reflect some of the items of change that you described in your narrative presentation?
They do. I think it's, almost all of that is what we have done.
Members of the commission, I would move that this be admitted into the record at this time.
No objection.
Okay.
And now, Mr. Krogan, I want to show you what's been marked as Exhibit 2, and I think you referred to this document in your narrative, and that's a 2-page document that is entitled Manager's Appointment of President / Authority and Duties. Do you recognize that document?
I do.
And do you know who prepared this document?
Counsel to Our Way, George Schmento.
And does this document bear your signature?
It does indeed.
And does it bear the signature of Mr. Ross?
It does indeed.
And is this the document that you were referring to in your testimony regarding some limitation on your authorities and some description of your duties?
It is.
And I want to direct your attention to paragraph 7, and ask you to read that paragraph.
John will not engage in self-dealing with Our Way. This includes any unilateral action without my written consent to pay himself compensation or benefits not specifically authorized by me or to transact personal business with Our Way. John agrees he will not hire or engage for Our Way in any capacity his family members or associates in other businesses in which he maintains an ownership stake without my specific written consent.
And at this time, I would move that this document be admitted into the record of this hearing.
No objection.
Now, as part of your plans, Mr. Grogan, have you created an organizational chart?
Yes, I have.
Okay, and is that a organizational chart that assumes gaming functions? Is that right?
We have two organization charts. We have the existing organization chart of our operating business, what we refer to as our harness business, and we've also, as our planning is developing for our Phase 2 application, our gaming organization chart. We envision that were we to receive the Category 2 license, that we have an organization chart that has in the heads of gaming operations, slot operations, human resources, IT, finance, security and surveillance, and the like. And so we contemplate that with that we would go out and search for the very best people in each of those categories if we were to move forward.
And are there specific positions reflected on that chart that relate to the compliance function?
It does. We expect to have general counsel there, so you've got compliance both at a corporate and at an operating level. Corporate level being both financial compliance, legal compliance, as well as operating compliance within the organization. We understand the regulations that we're going to face and be required to comply with, and we have built into our organizational chart people in those capacities.
Will there be anybody who will have responsibilities specifically for compliance and that will bear a job title that relates to compliance?
Again, envisioned to be through general counsel would be the chief compliance officer, and both the chief financial officer and legal counsel would have matrix reporting to the board of advisors as well as to the president of the company.
Now, in the course of the investigation, you were asked, and this is reflected in the report, about the role that Mr. Peterson has played in the organization up to his resignation. And how would you describe the function that he performed?
In the report, Mr. Peterson is described as functions as a controller. He's responsible for the cash management, check processing sort of aspect of that business, and the executive functions as described were something that he did not do. He, again, in the report, was described as following the direction from the president of the company. As I got this job on April 3rd, on April 4th, in my testimony to the IEB, I told them at that time that Mr. Peterson, if we were to receive a gaming license, would not be the chief financial officer of Plain Ridge Park.
To your knowledge, did Mr. Peterson know that was your view?
Yes, that was not, that was redacted in the redacted report. It was part of the confidential IEB report, and Mr. Peterson, as a qualifier, got the confidential IEB report. So he was aware of that.
Did you at any time have a specific conversation with him about whether he would be considered for the role of CFO sometime in the future?
CFO of Plain Ridge Park? No,
Yes.
no. It was clear that that we would be looking for somebody as a CFO. He acknowledged he was more of a controller, and that we were going to find a more, let's call it traditional chief financial officer.
As of Tuesday morning, when you described that staff meeting, had you communicated with Mr. Peterson anything about your expectations regarding his future employment with the company, as opposed to his role as CFO?
No, I mean, the assumption was he would continue.
Okay. Now, there was some discussion in the report, and certainly by Director Wells this morning, about certain investigations that occurred in the period between 2000 and 2004 or 5, and I think that involved state investigators. The question I want to ask you is, do the state police have a office, or are they present on the premises of the race course?
They are. They have an office. The Racing Commission does, as well as the state police. So there's state police presence on property daily.
And have you, did you, upon assuming your responsibilities, have some communication with the trooper that was present, or that is present at the race course?
I did. After I got this position, I learned about a difficult relationship, shall I say, between the state police and the former president. And he was, the trooper that is there has an office right next to our director of operations. I met him, had a conversation with him, and explained how that the practices at the track were changing, and wanted him to understand that we had a different view of our relationship with the state police. And I told him I wanted to come down into my office and we would talk about it. He had been in our building 5 days a week for 15 years. He told me he had never been in that office before. I said, come on down, sit down. I want to talk to you about what we're doing and how I want to change what we're doing. And I explained to him that our standards and the standards that we endeavored to set were a very high bar, and that if he had any concerns that there were regulations, laws being broken, he should absolutely come to me. I told him our standards were much higher than simply complying with law, and that I wanted to know about it instantly. He said, well, the practice before was that he was not allowed to talk to people unless management were present. And I said, that's no longer the case. I said, you know, you're here, you have access, and we want, if something is wrong, we will fix it. I want you to know that we will. Something might be wrong, we will fix it, bring it to me, and we will take care of it. And he explained, he said, you have to understand that's very different than how it's been. And I said, I understand that, I want you to know that it is.
Just for the record, I would not want our state police to be able to be told by a manager of any facility that they couldn't talk to anybody they wanted to talk to. So I see our troopers back there, you know, there's 2 levels of accountability in that conversation.
Finally, Mr. Grogan, I want to direct your attention to what is Exhibit 1 to this hearing, which is the notice of the adjudicatory proceeding. This is the July 10th, 2013 letter from Chairman Crosby. And I want to direct your attention to page 2, which identifies 3 topics in particular that the Commission wanted addressed. And so I want to direct your attention to them. And the first one, and I'll paraphrase, asks for confirmation whether the applicant historically lacked effective corporate governance and internal controls. And have you made a conclusion as to whether that statement is true?
Yes, I have. And as I said before earlier, that we have lacked effective controls in the past.
Okay. And it also, that same question asks for the nature, source, cause, duration, effects of, responsibility for, and correction of those problems. And have you, in your analysis of the deficiencies in the past, made some determination about nature, source, cause, duration, and effects?
Yes, and that again went back to my sort of analysis of what happened. So that responsibility is spread both by the prior management and lack of governance.
And the second question, or the second paragraph, asks the applicant to be prepared to address whether the applicant has instituted or immediately will institute internal controls, financial and accounting practices, et cetera, for the proper financial management and accounting required for a Category 2 gaming establishment. And have you, to the best of your knowledge and ability, first of all, address that question in your narrative testimony?
I think we have, and I think that we can make the distinction between financial accounting in internal controls. And so our accounting systems tracks and do all that. And so I think we have the financial management in place, and then what we're putting in is practices to make sure that any issues as it relates to communication between the board and the financial officer as well as the auditor. I mean, as we met with the auditor in April to go over the financial statements, this was the first time that the auditor had met with both the president and the board, and the board didn't exist before, but had gone over the financials with the president.
And finally, the third paragraph there asks for an attestation that the measures implemented and to be implemented will conform to standards to be determined by the Commission for proper financial management and accounting, and will prevent the recurrence of some of the events causing concern. Can you so attest before this Commission?
I can, and in fact, Chairman Crespi, I want to come back to this idea of trust me. One of the things that we're trying to do, and I believe will be successful, is not making this individual. This is not up to me. I mean, we want to institutionalize this. This is not solely dependent upon me. It is an institutional process that, again, that starts at our board, runs through me, and runs down throughout the entire organization. So this controls and governance, again, starts at the top and comes all the way down to people in our money room, to raising their hands, to making sure that we are complying in every aspect of that organization. So it is not individual-based. The problems we had in the past is we were an individual-based organization, and the goal now is to put this in a system and a culture of not only compliance as a sort of a regulatory term, but in fact, from practice of doing the right thing. So when you translate this to somebody in the money room, when you translate this to a teller, you're saying we're going to do the right thing. Compliance at some level might get lost in translation. It's do the right thing, and that's a culture. That's not individual. This is not up to me. This is up to everybody. Again, starting at our board and coming down.
When I said that, I didn't mean just trust you. I meant trust us is what's being said.
And I want it to be, it's an institutional process, and it's something that, given our history, is something that we all feel committed to, and the involvement of our members are here to assure, both for them and for you, that it will not happen.
That's all I have.
Yes, the counsel for the Bureau or
Yes,
the Bureau?
Mr. Chairman, the Bureau does have some questions of Mr. Grogan. I understand, Mr. Grogan, Mr. Pienkowski brought you on board as a business and a financial consultant in approximately 2009. I know you had other dealings with him, but with respect to the applicant in 2009.
Right.
And then at some point you stopped consulting, but then there was a break, and then you came back in 2011 and continued in an advisory capacity on the financial and the business side. Is that correct?
That is correct.
You have to answer for the record. Thank you.
Yes, that is correct.
So in connection with the work that Mr. Pienkowski wanted you to do when he brought you on board as a consultant, did he give you access to the financial records and financial material of Our Way?
I saw the annual financial statements. Yes, I did.
You
now,
did.
Just to understand, I worked in a separate building. The Plain Ridge Race Course is 301 Washington Street. My office was in a different part of Plainville, but I did in that I saw the audited financial statements.
Okay. And specifically, and these documents are not going to be marked or introduced into evidence, but in the financial statements for 2007 were prepared by a firm, Husted & Husted. I'm not sure I'm pronouncing that right, but does that, okay. And then, you have to answer, does that
sorry,
name?
I don't know.
You don't recall. You recall seeing the annual audited financial statements, but you can't recall
Who prepared them in
particulars, who prepared them.
2007? No,
Okay.
I can't.
So, and I take it from your previous testimony that that the financial statements reflected Our Way's financial position, and that position was declining in a fairly dramatic way from the period of time, say 2007 to 2011.
Yes, dramatic. I mean, revenues were going, revenues were
It
down.
was
It's
declining revenues,
Declining revenues, operating
negative
losses,
cash flow.
Negative cash flow,
Uh,
operating losses.
And that in particular, ROA was depending for its, literally its day-to-day existence on ongoing cash infusions from some of its members,
From all of its members.
from all its members. So, when you looked at these financial statements, and the financial statements reflected the red ink that seemed to be prevalent during this period, did you also note in the financial statements that they were reflecting a distribution on an annual basis to a member?
Again, while I had access to those financial statements, I was not analyzing the financial performance of the, what we'll call the existing business. Most of my efforts were focused on the business and financial model of the gaming business. So as we look at that, we separate it into two businesses, the gaming and the harness. So I had access to that, to the financial statements simply to help forecast the performance of the harness business as opposed to analyzing and reviewing and reading the footnotes. I was not reading them in that
Okay.
regard.
Oh, understood. So your focus was moving forward to the next generation of the
Yeah.
company, as it were. But nonetheless, as you're sitting here today, do you remember when you saw the financial statements, noting the fact that on the statements it did reflect on an annual basis a significant distribution to a member?
Yeah, no, I did not read those footnotes and see it that way.
You did not?
No, I
Okay.
didn't.
At some point, Mr. Grogan, despite the declining financial position of the company, you did learn, in fact, of these ongoing, apparently very regular distributions to one of the members, Mr. Pienkowski.
Yes.
Okay. How did you learn about this specifically?
It came about in the interview with Mr. Fulton in the end of March.
Okay. So prior to the sworn interview that you had with the folks here from the IEB, you had never spoken to Mr. Pienkowski about the distributions?
No.
And you had never spoken, I take it, to Mr. Peterson about the distributions?
No.
Had you ever spoken in your role as a financial and business consultant to Arway's outside auditors?
No.
Okay,
The only way would have been in collecting information on the phase one process, but my consulting at that time was really not focusing.
But the specific question is, did you ever have a conversation with Mr. Pienkowski, Mr. Peterson, or the auditors for Arway about these ongoing distributions?
Not that I can recall.
Okay. And the first you learned was your sworn interview?
Mhm.
Okay.
Not mine, sworn, Mr. Fulton.
I'm sorry, Mr. Fulton's sworn interview, I apologize. Now, do you have a copy of the Exhibit 4, the report before you? That might be helpful, just because I'm going to point to a couple points in that. And I just want to make sure we're on the same page. This is Exhibit number 4. It's the redacted report, and I just want to draw your attention, Mr. Grogan, to page 37. And it's in section 3 there, about 2/3 of the way down the page. It was the line that was referenced previously. Do you see the sentence beginning with "these withdrawals"?
Mm-hmm.
Okay. And for the record, the report states, "These withdrawals have been described by some of the members of the applicant, as well as Grogan, as an accommodation to Pienkowski."
Mm-hmm.
And I think you described it earlier today as an accommodation, but you also used the words acknowledgement, and you used the words understanding.
Mm-hmm.
Is that correct? Okay, you have to answer.
Yeah, I'm sorry,
Okay.
yes.
No, okay.
Thank you.
So, what I want to more fully understand is if it was an accommodation, if it was an understanding, if it was an acknowledgement, well, it was an understanding by whom? It was an accommodation by whom?
again, it would be in a combination and understanding by the members, major shareholders.
Okay, by the major shareholders.
Major shareholders.
And by major shareholders, just for the record, tell us who you mean.
Mr. Fulton, Mr. Ross.
Okay, and who are the other members who are not the major shareholders, at least the significant?
We have a total of 15
Okay.
members in the LLC.
Okay, so 2 of the 15 you
Two
would
of
describe
15.
as the major. I gave to your counsel this morning, Mr. Grogan, a very brief excerpt from your sworn testimony. And I don't know if you have that before you. Do you recall your sworn testimony, April 4th, 2013?
I do.
Okay, at the Office of the State Gaming Commission. And Ms. Scheibel asked you a series of questions, and I've just given you an excerpt because I want to make sure the record's clear about this. At the bottom of page 13, and this is during your sworn interview, Ms. Scheibel asked you the question. She says, and she's asking about the distributions that have been subject of testimony today. This is Ms. Scheibel. I'm sorry, if I can interrupt, when you say nothing was wrong, you mean in terms of operation? And you answered, and this is lines 3 through 5 on page 15, nothing was done wrong. The draws were an accommodation for the president, and it happened to be a member. So do you recall that answer?
I do.
Okay. And
I'm sorry. In the interest of completeness, since you quoted from it, and it's a rather lengthy answer, I think we might as well have the benefit of the full answer.
okay, that's fair enough, because I was going to get to the remainder of the question, and I will. Let me just simply read the entire answer into the record. Nothing was done wrong. The draws were an accommodation for the president, and it happened to be a member. So it was, you rounded corners. This is a money-losing track, so most of the communication to the members over the years was, what's the check this year? They're writing a check, so it's sort of, did it matter? The budgets and the numbers, as opposed to, is it $1.1 million, $1.2 million, $1.5 million, that was the question. They got one capital call a year to fund losses, and that was it. So again, you sit here, again, you sit there and say, should the controls have been better? Absolutely yes. Sort of nothing was, I'm thinking sort of bad/wrong, as opposed to poor governance and controls.
And if I can, I was trying to make that distinction between legal versus illegal. And when I sit there and say wrong from a control perspective, absolutely. But it was the question was sort of I'll say the legality question. So it was tracked and monitored. It was tracked from an accounting perspective, so that I don't want to convey the sense when it says it wasn't wrong. In that regard, that's what was not what I was intending to say.
Okay, that's helpful.
Clarify.
Now, just going back to this issue about your characterization of this as an accommodation, and then today you described it as an understanding or an acknowledgement. And if it was an acknowledgement by the owners or an accommodation by the owners, Mr. Fulton and Mr. Ross, I take it in particular, then I take it you had some basis for believing that the owners were aware of these distributions as they were happening.
I'm not sure I'd say as they were happening. What happened is in the week between, I would say in roughly week between the Mr. Fulton interview, and I don't have the date of that. So this was all a set of information that happened between then, sometime in the end of March, and that April 4th. And so to the extent, so this was with the understanding that came about as a result of conversations in that period of time.
I understand. So what you're saying was that when this pattern of conduct began many, many years ago, that it's not your testimony that at that time when it began there was an acknowledgement or an accommodation or an understanding that Mr. Piantowski was engaged in this. But in connection with the resolution of the issue in 2013, this year, it was treated in the fashion it was, as an accommodation by the owners to him.
The resolution wasn't, again, the method of the transfers versus the resolution are different, I think. I mean, the resolution was different from the capital withdrawal. So what I said was that the capital withdrawal was treated as an accommodation. The capital distribution for a member was an accommodation for the member, that capital withdrawal. The method, the nature of how that happened was, I don't believe, known to the members. What they saw was a number at the end of the year, as opposed to going through how did that happen? Was that a series of money room transfers, or was that a check or something different? I don't believe that they understood the nature of how that capital distribution came about.
Okay. Let me draw your attention back again to your sworn testimony. And, this is the previous page, page 13, and this is your sworn testimony taken at the Gaming Commission offices on Thursday, April 4th, 2013. And I just want to make sure that the record is clear here. And for the purposes of the record, let me read your entire answer on page 13, and then there are going to be parts of it that I want to focus in on. I'm sure Mr. Richland is going to make me read the entire answer, so why don't I just start with that? So the question from Ms. Scheibel is relates to the CFO, the then CFO, and would he have been responsible for putting some of these controls in place, some of the controls that you've talked about earlier today. And your answer is, I'm thinking no, in that I think the CFO would say to his boss, this is what I think we ought to do. So I think ultimately that responsibility is the boss's. Now, you've seen our letter about the draws. Those were done annually, so the auditor was saying, hey, we need to make sure this is okay, so it was done annually. Some of those things were there. I think ultimately it runs to the top, and also it runs to, I'll say the board, even though the board didn't quite exist. These were a bunch of passive investors, a control question. I think it's important we're talking about controls. From our side, we think nothing was wrong. It was sloppy, nothing was wrong. Did some of the members, I know you talked to them, did they know? No, they did not. I'm not sure they should. 5% passive investors, what do they know? I'm not sure. So, let me just ask a specific question, because you're probably anticipating correctly where I'm going. So it was your understanding at the point of your sworn interview on April 4th, 2013, that none of the members knew, or some of the members knew?
It was my understanding that the majority of the members did not know.
Okay.
That prior to, they were the qualifiers, Mr. Tuck, Mr. Shinowski, and Mr. Shimento were specifically asked about these, and they did not know.
And when you say they were specifically asked, would that be by the IEB team
the
here
IEB team,
during their interviews?
That February letter from 2012. I believe they were asked, did they know? And it's my understanding that they did not know.
And you've identified those members who did not know. But what about Mr. Fulton and Mr. Ross?
No, again, as it's in the report, and Mr. Ross is, when asked, he did not have recollection of the document. And I know that was what he said.
Not only did he not have recollection of the document, but it's pretty the report reflects, does it not, that Mr. Fulton denied knowing about the distributions that were taking place in the fashion they were taking place.
That's correct.
And just to be clear, page 39, page 39 of the report. That middle paragraph there between the two blacked out areas, right in the middle of it, it says, although the investigation confirmed that such money room distributions did occur, it could not definitively confirm whether such distributions were knowingly approved by Fulton. In fact, in his first interview, Fulton denied having any recollection of having approved these distributions. And I take it from your testimony that you don't have any information that Mr. Fulton did approve the distributions, but as a resolution to the issues with Mr. Piankowski, an accommodation was made that enabled a resolution.
Yes. I'll come back, and the interview with Mr. Fulton, and again, it was sort of unique, somewhat unusual that I was there for that, was a startling interview. It was a number of things came out in that that I think was certainly unknown. So it again, and it was the pattern, the practice, all of that was brought out in that interview, and it was new information.
Okay.
Certainly to Mr. Fulton, certainly to me.
After the sworn interview of Mr. Fulton, which you say was the first that you learned of this, and the first that Mr. Fulton learned of this pattern of conduct, did you then have conversations with the members about it? With any of the members? Mr. Fulton, Mr. Ross, or?
Mr. Fulton, Mr. Ross.
Okay. Can you share those, please?
Yes. We began to, again, with the questions, with the line of questions, with all of the things that were coming up, we began, we fully appreciated for the moment sort of that the practice of controls, what was going on, was not known, and that needed to be fixed. And again, as we come back, it was something that needed to be done quickly, efficiently, the best way, thinking about the company rather than saying, how are we treating Mr. Piankowski at the time? The question was what was the right thing for our way moving forward
So it
from a pragmatic business perspective.
Okay. So it sounds like the focus was on moving forward, attempting to address the problem.
Again, deal with the issue with then former president, and then fixing that going forward.
In any of the conversations you had after this interview of Mr. Fulton, when it all came to light, did either Mr. Fulton or Mr. Ross or any of the other members said, oh, no problem, I told Mr. Piankowski he could do that, I was aware of it, I let him do it? Any conversation to that effect whatsoever? Okay. Do you?
Is that a no?
I'm sorry, no.
Do you have Exhibit 5 in front of you? That's the audit, the letters from the outside auditors addressed to Mr. Fulton and Mr. Ross. I think they have copies. Okay. And you've still got the report in front of you too?
Yeah.
Sorry. I'm making things complicated for you. So let me just, first, just to orient ourselves, page 38 of the report. The first full paragraph on page 38, are you there? First full paragraph on page 38. About halfway down that paragraph, a sentence beginning with the word, well, let me go up a couple of sentences. The sentence beginning, the outside auditor, do you see that? Okay. The outside auditor indicated, I'm reading from the report now, page 38, that the first letter prepared was for calendar year 2008. Each year, these letters were submitted to Piankowski in his capacity as the manager for Arway. However, the outside auditor indicated that although these letters were submitted to Piankowski each year, it was not until February 2012 when he actually received the letter back signed by Fulton and Ross. The February 2012 letter listed the advances made to Piankowski for calendar year 2011. The 2012 letter also now reported the previous advances made to Piankowski for calendar years 2004 through 2010. And you understand that exhibit number 5 is this last letter that's referenced in the report. Okay. There are not only exhibit number 5, but the outside auditor apparently reported that similar letters were prepared on an annual basis. Have you ever seen any of these letters?
No, there is a letter from, I believe, there was a 2008 letter that I have seen.
And tell me who it's to and who it's from.
If I get it, it was 2008. Mr. Tuck was the manager at the time, and it listed the distributions in that year. So there was, so I'll say, bookend letters.
And then, but you haven't seen a letter from
In
between. Okay.
Correct.
This would you say 2008?
That was my memory.
Okay. Was it a letter similar in form, addressed to Mr. Fulton, Mr. Ross, with the
It
same?
wasn't Fulton and Ross. I think Tuck was the manager at the time.
Okay. Pardon me. You said that. Now, when was the? Be fair to say that, you know, as of February 7th, 2012, you were a consultant to the company at that point, acting in a business advisor, financial advisory capacity. Did either Mr. Fulton or Mr. Ross or Mr. Piankowski show you this letter? When is the first time you saw the letter?
This is the February 12th letter.
Yes.
Yeah, in Mr. Fulton's interview.
Okay, in his sworn
Yes, it might have been before that. I remember it went, so when it went, it would have gone through me as part of the phase 1 process. So I know it went some period of time before the end of March. It just didn't, so it went from the company to BIEV.
Okay, but in 2012,
Yeah.
it was something you'd seen in connection with this investigation,
Yeah,
not
we had not seen it before.
in around the time that it was prepared or signed off on. After you first saw the letter when it came to light during this process, did you ever discuss the letter with Mr. Fulton or Mr. Ross?
Talk about this letter. Well,
Yes, Exhibit 5, I'm sorry.
It generated a lot of conversation post that.
Okay. Did either Mr. Fulton, well, describe that conversation.
Well,
to me.
again, the concerns about what was happening. Again, and even still, this letter doesn't talk about the method that those were happening. But again, the levels and the concerns were expressed and we talked about.
Did Mr. Fulton tell you that he, when the letter came to light during his sworn interview in 2013, and you had conversations with him, did he tell you that he recalled seeing the letter a year previously and recalled signing it?
No, again, you have his statement in that interview that he doesn't recall.
Okay. And he never said anything to you that was inconsistent with that? Okay. What about Mr. Ross? Did Mr. Ross ever acknowledge to you that in fact, yes, he had seen the letter in approximately 2012 and that he had signed the letter and returned it?
I believe he had a better recollection of the signing that letter.
Okay.
But I would say sort of without fully understanding what was in it.
Okay. Well, what specifically did Mr. Ross say to you about the letter?
I would have trouble recalling a specific conversation, but that he had recalled seeing it and understanding, but not the nature and the method.
At this point, let me, Mr. Richland, we do not have a copy of the 2008 letter in our files, so I would ask that if you still maintain a copy, if your client maintains a copy, if you could produce it, that would be very helpful to us. Thank you. I take it these discussions that you had with Mr. Ross about this letter, these were, after the letter had come to light in March 2013. Okay. I just want the record to be as clear as it can be, that as you sit here today, you don't have any reason to believe that the distributions to Mr. Piantowski from the money room were done with the assent or understanding or agreement of any of the members of our way.
Correct.
Thank you. Now, shortly after you learned about the distributions in March of this year, did you, at that point you were a consultant, I understand, only later then did you become president, but either as a consultant or when you became president, did you suggest or direct any further investigation into the matter?
I did not.
For example, did you suggest or direct, either as a consultant or as the president, that that there be an investigation into whether others at Our Way might have been involved in facilitating these distributions in some way?
I did not.
Okay. And do you recall suggesting or directing an investigation or an inquiry into whether others at Our Way, in addition to Mr. Piankowski, might have benefited from these distributions to Mr. Piankowski?
I did not.
Now, I want to touch briefly on the internal controls that Our Way is, I understand, working very hard to get up to speed and running now. Would it, and you actually, I think you mentioned this in your testimony, Mr. Grogan, but correct me if I'm wrong, wouldn't it be fair to say that one of the internal control problems or cultural problems, I'm not sure exactly what you'd call it, but one of the issues at Our Way might have been that employees like Mr. Peterson, who's not here today, were afraid to complain to people higher up in the company?
I think that's accurate.
Okay. In fact, they were afraid for their jobs or their career advancement or whatever.
That's correct.
Okay. So, and I think you also said this in your direct testimony, that policies and procedures and internal controls, you can write them down on a piece of paper and they're great, but if employees are afraid to follow them or they don't follow them for whatever reason, they're really not worth much more than the paper they're written on. Fair
That's
statement?
correct. It is.
Okay. So, how do the changes that you are working hard to put into place at the applicant's business, how do they specifically encourage individuals to speak up, even if they need to speak up going over the heads of their bosses to do it? How do you, well, I think you get the question.
Yeah, I get the question. A good example is we had, the 1 week plan was to put limits on advances from the money room. So we had a petty cash limitation of $300, which could be done by director of operations and director of racing. So there'd be normal course of events, reasons why you would need put gas in a truck or to do other things that happened. I want to say 2 weeks ago, a petty cash request came in for an appropriate, it was a purchase for something that someone needed cash for, they couldn't use a check or they couldn't use a credit card for. And a request came in for a $500 advance. The head of the money room bounced that up to me and said, you can't do it unless I sign off. Right? Our policy said $300. It didn't say there was an exception for me above $300. It said, no, you can't do that. And so it was again, a seemingly simple thing But that practice and the head of the money room feels very, feels strongly about that position. And so here was a perfect example of the self-enforcing by the people responsible to bounce that up. And I said, I can't do that. And we had to do it a different way.
How do you communicate to your employees that it's okay, under certain circumstances, to go over the head of your boss if you see something that's inappropriate or dishonest or illegal?
We tell them, so we have weekly management meetings, we have monthly group staff meetings, in suggesting that questions are appropriate. I've said that to the managers. We had company-wide meetings after I took this job, and I want people to know that it is fair to question your boss. Both the people should question their supervisors, and supervisors should be comfortable with the questions, and if you can't answer them, you should do that. So even people come in and question me all the time, and that's a rewarded behavior, not a criticized behavior.
I want to ask you a series of questions about whether there's any ongoing relationship with Mr. Piankowski. He left the company in early April this year, correct? Does he have any ongoing role in the company today?
No, none.
Does Mr. Piankowski have access to the offices, for example?
No.
You
Yeah,
hesitated.
I'm sorry, no, I mean, to my knowledge, we are in a public building, per se. I don't believe he has stepped foot in the building since his departure.
Okay. Would he be able to? Does he still have a key or a passcode or whatever you need?
Locks were changed, passwords were changed, signature cards were changed.
Were those changes made specifically with regard to Mr. Piankowski's departure?
Yes.
What about access to the computer system, passwords and the like?
All that, so all that was ended.
Okay, take it he has no access to the money room at this point.
No, he does not.
Okay. Is Mr. Piankowski's brother still employed at the
Yes,
track?
he is. His brother is a customer service manager.
Okay. Just tell me what that involves and who that position reports to.
We have sort of we call it a general manager, a person who's responsible for conduct of the building. So we're open approximately, say, 12 p.m. to 12 a.m. every day. We have a general manager, or a what we now call a customer service manager, that's on duty all of those times. Chet Piankowski is that, so resolving issues with customers. If we have any sorts of problems, they're the first line, and the customer service managers report to the director of customer service, who then reports to me.
Okay.
Excuse me, Mr. Mackey, how much more time do you need here?
5 minutes.
Okay, so we'll go ahead and we'll think about taking a break.
Okay. I
Go
can
ahead.
break now if that's.
No, if you've got 5 minutes, let's go
Okay.
ahead.
There was some discussion earlier when you gave your direct testimony about the circumstances under which, I'm sorry, not the circumstances, but the conditions under which Mr. Piankowski left the company. I take it at no point did the company ask Mr. Piankowski to pay back the distributions that he had taken over the years.
They did not.
And why not?
Again, it was part of the separation, and our goal was to be able to effect the separation as quickly and as effectively as possible. And it was part of, and that was, there were a number of aspects to that, but we wanted to end that and move on.
I think the commission members were asking this question, and I'm going to ask it again maybe in a slightly different way, but by not terminating Mr. Piankowski for cause, by not demanding the money back, and by instead giving him a generous by some measure severance package, do you have concern on the part of the company that sends a message to the Bureau, to the Commission, and to this industry about your company's attitudes towards this kind of misbehavior?
Our company's attitude towards this behavior, how we separated Mr. Piantowski was done at the time and without the benefit of hindsight about how it would appear. It was a pragmatic business decision. It is not meant to convey acceptance of any of that, and it's not condoned. It will not be condoned, and it's not meant to convey that.
Okay. Just a couple of questions about Mr. Peterson, if you would. It's your testimony that his resignation was purely voluntary on his part.
Absolutely.
Was there a separation agreement executed between Mr. Peterson and the company at the time he left?
Let me be perfectly clear how this happened. A call from his lawyer went to our lawyer suggesting he was resigning. And in fact, I subsequently asked our counsel, how do we know he's not working? We do not have a resignation letter. He walked out on Tuesday. What happened was, again, counsel gets the call, counsel calls back, accept the resignation. He said, make sure he comes up. Someone is in your office, had a 2-minute conversation with him. He dropped his keys off and walked out the door. There is no resignation letter. There's no separation agreement. He walked into my office. He dropped the keys. He turned around and walked out.
So I take it the fact he dropped the keys off means he doesn't have access to the facility anymore.
Well, again, we are in a public building. His office.
I'm sorry, into a
Correct.
private office space or other sensitive areas,
That's
non-public areas.
Right.
Are you aware that Mr. Peterson had taken out a loan from the company?
I am.
Okay. What's the disposition of that loan, if
one of-
any, I should say?
Sure. One of the things that happened, and this was a direct result of our first meeting with the auditors in the end of the month to go over the audited financial statements, there was a receivable account in that financial statement. And at which point we had a discussion about what was in that receivable account. In that receivable account was a loan. The largest aspect in that receivable account was a loan to Mr. Peterson. There were some other employee loans, and there were some I'll say where miscellaneous receivables within. I think we stored sort of uncollected but still possibly collected checks. So there was a long list of things on there. That was the first time that I became aware of the loan to Mr. Peterson, at which point I told him he should repay the loan. And it was
And forgive me, give me the time frame of this discussion again.
This was our meeting with the auditor, which would have been around the end of April.
Okay.
So when told him to repay the loan, had a conversation with our chairman about this. Again, he was unaware of that and said, this has to be repaid. So I told Mr. Peterson that we wanted the loan repaid. He explained sort of what would it take to be able to do that. Last Tuesday, approximately, he told me that he had the check and had repaid the loan. So the loan is repaid, to my understanding.
Okay. With respect to the loan, do you have any information that it sounds like you were not aware of it until quite recently.
That's correct.
Pending this during the course of this investigation. Do you have any information that any of the members were aware of the loan to Mr. Peterson?
Absolutely. And it wasn't pending the investigation. This came out as a result of our normal audit conversation with our auditors. So it wasn't an investigation question. I'm sorry, I take that back. There was, yes, there was a document, a loan document in the investigation process.
Okay.
But this, the repayment and all that was a result of our normal.
Do you have any information, as you're sitting here today, that before it came to light, in the fashion you described, that anyone at the company other than Mr. Piankowski knew about the loan?
I wouldn't think anyone else would have.
If I might just confer with my colleague for 1 minute?
Mr. Chairman, we have,
Okay, good.
we have the 2008 letter. I was under the impression that the commission already had this. And so if we're going to take a break here, I'd like to give it to Mr. Mackey so that if he wants, so he has a chance to read it, and if he wants to have some additional questions, and we'll see if we can make copies so that the commission has it as well.
Fine, great.
Okay, that's fine.
Anything else?
One additional question.
Okay.
In terms of staffing going forward, is the person who is the head of the money room going forward the same person who would have been the head of the money room in previous years?
We have the head of the money room right now, so going, Paul is the head. Going forward, meaning in a category 2
Yes.
question, I don't know the answer to that.
Okay. No decision's been made.
Absolutely.
Okay, thank you. I have nothing further.
Okay, I think we would like to continue this, but it's been a little while. Why don't we see if we can try to keep it to a 10-minute break. We'll be back 10 minutes of 3. We're going to convene again, folks.
The team's assembled.
Well, they're gonna see this.
We're waiting, I think, on the Bureau and Council to, are there other cross-examination that you wanted to conduct?
We are
You're
concluded with our questions of Mr.
Okay.
Grogan.
Okay. Commissioners, questions for Mr. Grogan?
I had a couple, and I'll be brief, because I asked a series before. Mr. Grogan, when I was asking you questions before, I conflated the date on Exhibit 5 with the date of the interview by a year, I think. So it's fair to say, is it not, that none of the changes that you've talked about instituting were instituted between February 7, 2012 and April 3 of 2013,
That is correct.
about 14 months. And it's also, do you know whether at the end of 2012, the same kind of increase to the capital account that's reflected in Exhibit 5 occurred again?
It's yes,
It did, at the end of 2012.
yes.
Yes.
After the March 3 interview, March 3, March 4, the interview that you attended with Mr. Fulton, then there was a discussion about what to do about the revelations that had occurred during the course of that interview, if I understand your testimony correctly.
That's correct.
And those revelations reached a resolution, and the activities reached a resolution on or about the 2nd or 3rd of April.
Correct.
And at any time during those that about 1 month period, did Mr. Piantowski tell you, or to your knowledge, any of the other principals that he wanted to retire because of illness?
He had well-documented health issues, but this was the health issues were not driving this resignation.
So the answer is, if I understand you, no, he never raised that, and none of you ever raised the illness as a reason for his retirement.
That's correct.
Exhibit 2 is the plan that Mr. Ross and you signed, installing you as the president of Our Way.
Yes.
your Exhibit 2, or the Our Way Exhibit 2.
Yes.
Is there another agreement that has superseded that agreement?
Yes, there is. The appointment of Mr. Fulton as CEO superseded this one, and that one was dated July 17th and forwarded to the IEB.
Okay. And do we have a copy of that we could,
I did
I know we
receive
have a
that
copy of it. Could we mark a copy of that with everybody's agreement as perhaps Commission Exhibit 6?
No objection.
And the essence of that agreement, insofar as it makes changes, is to install Mr. Fulton as the CEO,
Correct.
and you remain as the president,
Yes.
and Mr. Ross is the manager.
Yes.
And it also makes a number, contains a number of provisions in which the agreement of all three is necessary for certain action to be taken. Is that right?
I would have to.
All right. The agreement really speaks for itself. Was Mr. Ross a participant in the discussions between March 3rd and April 3rd of 2013 with respect to the removal of Mr. Piantowski?
Yes.
And I take it he was heavily involved in those discussions, as you were and as Mr. Fulton was.
Yes.
Is it fair to characterize it that way?
I think it is.
All right. Thank you. That's it.
I had a couple of questions as well. It's not clear to me, Mr. Grogan, how you feel as the new president of the company about these disbursements. You've characterized them in a few different ways, but I mean, the seriousness of it, how is it? I'm just not sure what your personal opinion is about this.
Let me make that perfectly clear, Commissioner Kenley. They were wrong, never should have happened, and never will happen again. So there is, in my testimony to the IEB, I was trying to make a legal distinction, but as a pattern of practice, it should never have happened.
Mm-hmm. The reason I was unsure is in reviewing your interview, you speak glowingly about Mr. Piantowski, as you do about Mr. Peterson.
Gary was a personal friend, and so when I speak, I would want to go back and look at what it was, but that so a number of things, Mr. Piantowski had a number of strengths, and he was a friend. None of that, though, changes how I feel about the money room practice in terms of, and there should be no misunderstanding about what my position on that is. It was wrong, never should have happened, will never happen again.
Mm-hmm. Also, was the resignation a face-saving move as opposed to a termination? You know, it was widely reported in the press and throughout that he had health issues, and that was not corrected by anyone. Is that just a way of saving face? Am I characterizing that properly?
Well, again, correcting. This was his removal from the company. Again, what we were doing from a company perspective, wanted to effectively deal with this. I think that his resignation did that. How it got characterized by the press, I don't think was meant to be necessarily face-saving for him, but it was meant to manage a process from our waste perspective. Our goal at all points was making sure that we could proceed, continue to move on, and I think protracted litigation around this would have been to the greater detriment of our way, and it was something that we wanted to avoid.
Okay. In reviewing your plans with internal controls, compliance, just wondering if you have any evidence in the last couple of months since you since you put your plan into action, do you have minutes from meetings or any kind of records of employees being trained with these new policies? Is there any?
Again, part of the written policies that were done was from, the ones submitted were money rooms and teller policies, and so what we were doing was documenting sort of pattern of practice, and so it was not, so that, when you say training, some of that was not a change of pattern or a change of behavior that was done, it was writing down what was done. What we're doing in many aspects of the company runs well in a number of areas, and what we're doing is we're writing down what we do. And so, but these have been communicated, particularly as we're changing behaviors within our tellers, so that these are being communicated to them.
Okay. Last question, sir. To your knowledge, does Mr. Peterson or Mr. Piankowski have information that could have an effect on your suitability? If that information were to come to the attention of the commission or the press?
Do they? No, they do not. The thought that Mr. Peterson's resignation was something that we wanted to happen, trust me, as the president, having him leave creates problems for us. And so aside from this forum, we have a company to run. He ran that, and the financial controls and all the financial accounting, I'd say was appropriate for what we were doing, and we need to deal with that. I wished Mr. Peterson were here today, and I wished Mr. Peterson were here at the company on Monday.
We wish he were here as well.
We all do.
Thank you.
Commissioners?
Yeah, I have a couple of questions. Could you remind us who the Board of Advisors is
Okay, so
that you
we-
referred to earlier? in
We
your
have,
testimony?
the idea was 3 inside, 2 out. One of the outside we haven't identified yet. Of the 3 inside members are Mr. Ross, Mr. Fulton, Mr. Levine, the venture capitalist from Washington, and then the outside director is Mr. Berman, the past president of Memorial Drive Trust. And again, a to-be-determined 5th director. We're looking for someone that would bring a set of skills and experience that would complement the skills and experience of that 4.
And you also spoke about the recent appointment of Mr. Fulton as the CEO, Mr. Ross as the manager. But the report speaks about how Mr. Ross is not anticipated to be involved in the day-to-day operations. Is that still the case?
Yes, it is. I think of him as chairman of the board, so you tend not to think of chairmen of boards involved in the day-to-day. Again, those day-to-day duties, obligations, responsibilities are delegated to me.
So is it fair to say that there will still be only one president in the day-to-day, one person, one individual running the day-to-day on site?
Yeah, I am the president of the company, and so the day-to-day responsibilities are mine, and through me, through the various department managers.
But is there a second individual that provides the separation of duty that will be running day-to-day or involved in day-to-day operations from these 3 individuals that you described? Or where are the other 2 key individuals residing and operating?
Other 2, you mean on the board of advisors?
No, Mr. Fulton and Mr. Ross.
Right, again, so Mr. Ross is, lives in Massachusetts. He, again, the chairman. The contact that I have with our board of advisors is extensive. I would say that I talk with each member of the board weekly, and in some cases daily. Mr. Fulton lives in Nevada, But my conversations with him, and again, this is as of April 17th, is the role as the CEO. And again, he is the executive officer, not the operating officer. As president, I am closer to the COO and responsible for sort of operations. So what these two gentlemen do is bring a level of, again, theirs is oversight and is governance. And as we move forward, certainly Mr. Fulton's expertise in the gaming industry will be invaluable to us as we move forward. But coming back, so day-to-day operations, though, is my responsibility.
You also, there's one of the exhibits, maybe I should, Exhibit 1. I think you dated it as July 17th. Is that the latest version of the internal control plan, governance and internal control plan?
July 17th was the date of Mr. Fulton's appointment as CEO. We have a more current version of our internal controls. It would have, you're right, since this references Mr. Fulton as the CEO, it would have been done after that date. This is a somewhat, I'll say, a living document. It improves, for instance, it talks about signature levels, and those signature levels and the levels at which requires two signatures changes and has changed from when it was first drafted.
Is there more detail behind this one-pager?
There are, as we talk about policies and procedures, there are things behind that. Again, this is meant to be a high-level document. So there is detail behind that. Again, our plans for organizational chart, lines of authority changes, and those and those aspects of operations. So there is detail behind that. This is meant as a framework for our board to understand what's being done.
And so is that detail that what you characterized as the written policies and procedures that you are nearing completion?
Well, some of them have been done. The written policies as it relates to money room and tellers and the mutual business has been submitted. For instance, our racing policies and procedures, and interestingly enough, when we got this report early in July, there was I read in there an incident regarding fines at the track. And in fact, we had a conversation in our staff meeting, the first staff meeting we had after we got that, to make sure that we incorporated the fines into that policies and procedures. So it's continuing to get close on racing. We have mutuals and finance already submitted to the IUB.
So who is writing generally these policies and procedures?
What I've given them to is to the department heads, to the people who are responsible. So we have the director of racing is doing that. We had both our financial officer and the money room do the money room procedures. We're doing this in a inventory control is being done at food and beverage manager is doing inventory control at that level. So this is a department level authors and then reviewed by the management before we adopt them.
Mm-hmm. So you also talked about enforcing and monitoring as a key part of the policies. Can you expound a little bit more on who as an individual or committee or maybe tasked with that?
It would be different for each department, and so what that specifically related to was we had changed policies around employee bedding at the facility, and so part of that was one thing to say it. The next question is how do you do that? So what we're putting in place is a procedure where we close out a teller mid-shift to make sure that and looking for a short mid-shift as opposed to something happening at the end of shift. So in that particular case, that would be something done by the money room. In all instances of internal controls, there's checks and balances and making sure that that exists, and so that the person checking can't be the checker can't check themselves. And so in that particular case, we're having the money room do that as opposed to somebody in the teller function.
I wanted to ask you also about the loans. I guess in order to cover the operating deficit, Mr. Fulton, I believe, has issued a number of loans to our way. Is that a fair statement?
Traditionally, what is done is that the operating losses, the losses from our operating business are covered by capital, raising capital from the members. So our losses are capital provided from them. Mr. Fulton has provided loans as it related to the construction of our garage, so the loans, we're not funding operating losses through loans. The operating losses are funded through capital calls to the membership.
So those loans are expected to be repaid, and they bear interest. And
They bear interest. Again, the interest accrues on the more recent, what we call the garage loan. But yes, I mean, it is well, I'll back up. The garage loan is part of the financial commitment that's being made for the Category 2 process. And again, that's a financing commitment. It's an equity commitment. If you read the financing commitment, it is a preferred member interest. And so we'll get back to the very complicated nature of the structure of what we think we're going to have going forward. But much of that shareholder debt will be reclassified as a preferred member interest, or something akin to preferred stock.
okay. Help me understand, please. I think somewhere in the report there's characterization about some of these some certain loans that were made by Anchor. I forget which one of the companies. But then Anchor, certain Anchor entities were sold to IGT eventually. Does IGT have a claim back to our way because of the nature of those loans?
There is a reference to IGT has no financial interest in our way. There exists, as it relates to Anchor Partners' original transaction with our way, gave certain business rights to IGT. Anchor Partners got certain business rights as it related to our way.
Which were the rights were the exclusive right to deliver the games, fairly
Correct.
deal, right?
And to operate.
So yes, so they have those business rights, and so that was when Anchor was acquired. Those flowed to IGT, but there's not a financial. It's not. There's no debt. There's no
Receivable.
There's no receivable. There's nothing that relates from a financial arrangement. There's a business right agreement that IGT has.
But if I could, Commissioner, if I could expand on this, because this is one of be my questions too. That the issue, all this issue about lack of controls and what Piantowski did and so forth. Obviously, the issue we're dealing with is this an organization that's ready to be in this business, and if it were just those issues, that would be one thing significant. But it strikes me that here is this deal, and maybe you can explain this. Basically, as I understand, the initial financing essentially was a loan from Anchor to our way, in exchange for which they got exclusive rights. Anchor got exclusive rights, I thought, to just deliver the games, Mary apparently to deliver the games and operate. Subsequently, there's been a sale of that right, sort of, to IGT, maybe a purchase back of that right. And as I understand it, that right, which is a very big deal in the operation of a casino, is unknown as to who has what right. IGT is claiming that it will not release the claim that it still has those rights, and somebody, I believe maybe Mr. Fulton, said there's no way in the world that IGT has that right. So can somebody explain to me why nobody, you I think referred to the document behind this as a, quote, horribly drafted document. Who is running this shop, and who is behind this transaction, and how does it stand at this stage of the game?
Again, there is this business right that IGT has, and And it's to provide all the operations associated with a category, and now what we will call a Category 2 gaming license. And there are certain economics around that. Those economics, I would say, are extraordinarily favorable towards our way. And that and this is something that we would be very happy for IGT to exercise. There are conversations ongoing about resolving this, and we're confident of a positive resolution.
Do I, go
I'm
ahead.
sorry. Go ahead.
Do I remember correctly that the report said that, was it Mr. Fulton who said that he doesn't agree with, that IGT has this right? Do I remember correctly?
Yes.
Yes, okay.
That's right.
So,
I'm sorry.
I believe that's correct.
in Mr. Fulton's statement, he says that he is clear that IGT does not have any such.
Well, again, I think
Well,
what
maybe
it.
we'll save this for Mr. Fulton
You
till he
can,
gets.
but again, the question is it's the intent of the parties, and it's very interesting. The intent of the parties, Mr. Fulton signed that agreement as anchor partners. The intent of the parties is for IGT to do this, and this is an obligation that they have. And so it's not a question that they don't have, it's an obligation that they do have.
So could I just jump in here for a second? So do I understand you correctly, that if Our Way receives the Category 2 license, it is Our Way's intention to turn the operation of their licensed facility over to IGT, both for the supply of the machines and for the operation of the facility after the machines are delivered, installed, and up and running. It's a turnkey agreement, basically.
It is a turnkey agreement. I think we will have resolution of that. That operating, turnkey operations was a business model of Anchor Gaming's. It is not a business practice of IGT, is our understanding, and I suspect there may be a resolution to that.
But this is not something, but operation in some way, shape, or form and by IGT and supply of the machines by IGT is not something that Our Way opposes.
No.
There's not an adversary relationship, in your view, between there's negotiations to be worked out.
I think
But
there's
not an adversary
there is differing of opinions, I think is a fair statement.
Okay. But, and I know I'm beating a dead horse, but part of the business plan is in some way to come to a resolution with IGT so that IGT can have a major operating and supply role in the Category 2 license if Our Way receives it.
I don't think the resolution would necessarily be that. But IGT is not in the operating, is not in the business of operating gaming facilities. That is not their business. To my knowledge, they don't do that.
Why don't we come back to this when Mr. Fulton is speaking, because part of the issue is his characterization of this as well, so we'll come back to that. Excuse me, that was on my agenda too.
No, you did better.
Were you finished? Yep. Mr. Stebbins, did you have anything?
I do. Just to be clear, the manager's appointment of the president, authority and duties is kind of superseded now by the appointment of the manager's action, or the appointment of the CEO and the president.
That's correct.
So stipulation, item number 2, under your appointment, I think back in April, that they were going to work in good faith to develop a mutually agreeable employment contract has kind of gone by the boards?
That did not make it into the most recent version of that agreement. That's correct.
Okay. You might want Mr. Richland to represent you in the future.
It may still be a topic of conversation, but it's not a written understanding.
Okay, just to draw some clarification. I guess I also had some concern, I think my colleague expressed it, about Exhibit 1, that there is documentation kind of behind all of these items, and again, can you give me a rough time frame as to when this document was pulled together? The Our Way applicant exhibit number 1?
I'd say the grandfather of that document was April 4th,
Okay.
and it's continued to move on. It was the governance and internal control plan, and so this was my plan when I came in to sort of address the immediate issues that we saw.
Okay.
And so that's, so you see the separation of the positions, the board of advisors, the internal controls. These were all actions that I would take to immediately address the issues that we faced at that time.
Yeah. Would you characterize the creation of the Board of Advisors as an immediate measure?
I had a 1 week and I had a 1 month plan. The 1
Okay.
week plan was money room withdrawals, employee conduct, matrix reporting of the CFO. The Board of Advisors was part of the 1 month plan. And so I would make the distinction between the two.
You've talked about not only instituting a series of financial controls, et cetera, throughout the business, but probably characterizes a change in attitude, a change in how the place operates. I think from your background, there's no question about your experience instituting financial controls. Can you discuss your background or any experience you've had in kind of where you've had an opportunity in the past to kind of create the operational changes, how people react, how you might have been involved in an experience where, okay, we got to change the culture, you should feel free to take a question to your boss and kind of create that environment. Can you share in maybe a little more detail where you've had that experience?
Again, a number of experiences. One is earlier in my career, I ran the investment banking division of Shawmut Bank. As we go back into my background, probably everybody I've worked for no longer exists because of changes in the financial services industry. But so I have worked in highly regulated industry, and certainly commercial banking is highly regulated. So I've had that experience of running that organization. I wasn't changing culture so much there. In a number of situations, both on the investment banking side with clients, sort of having seen a wide range of business executives in terms of how they implemented those. I've drawn on those experiences as I've doing this here. We are a 140-person organization, and what I am endeavoring to do when we think of culture change is really my views and communicated through the managers directly to the employees.
If I could just, I was going to raise the same question, Commissioner. Very good point. And it seemed to, you're a chief operating officer of an organization whose CEO is non-resident. It isn't a huge organization, but it's a pretty complicated organization with a lot of moving parts. And you are tasked with big issues, which is prepare for a massive possible future, change radically the culture of accountability and responsibility, institute a whole sweeping set of new controls and performance standards, performance metrics, presumably. That's a very tall order, and it takes experienced managers to do that. But it doesn't seem to me like you really have that kind of chief operating experience in your background. You've seen it as a consultant and can pick and choose from folks who've done it well and you've had some management responsibilities in a financial institution, but to be the chief operating officer of a real operating entity, particularly with these kinds of challenges, is a horse, so to speak, of a different color.
I'm not sure I would quite characterize it that way, Mr. Chairman. The most important thing that I'm doing as we think of changing culture, I think, is an attitude that gets conveyed out through this company. The people that report to me run that business. I've been described as an entrepreneurial manager. So what we've done is we've said each of the department managers are responsible for their business. And so in that regard, I manage now 5 people, and they're responsible for managing people underneath them. So in that regard, while I am the operating officer, the actual implementation of the operations of the managers that are there, they've been there for 15 years, they know how to run it. While we're putting in written policies and procedures, the change is a cultural change, not a practice change. So I think many of the things, making sure that people feel comfortable questioning authority, making mistakes, moving on, is something that I have done and can do, as opposed to direct operations. I've got 5 people who do a very good job and have a history of doing it well.
Can you, sorry.
Yeah.
Okay. You share a little more detail about your role as a consultant when Mr. Piankowski obviously is doing some financial modeling, but I think earlier in your testimony you talked about looking at the business aspects of casino gaming or a slots parlor coming into play with the operations of Plainridge.
So I started, again, trying to understand sort of expanded gaming as it related to Plainridge, and as I thought about the finance and the ramifications. I was also involved starting in probably after passage of the Act and developing the Phase 1 process. So it was a challenge. Our Phase 1 was perhaps a little different than some of the other applicants' Phase 1s, and they having been through that process before. And I know the team at Michael and Carol were very understanding as we went through gathering that information. And then also starting to plan and help build the consultant team that we have for our Phase 2 process. And so we were doing many of the same things that you are as we're entering into something new and building a group of consultants to help advise us. And so that I have been involved in doing that.
I guess I have a question, and it relates to the withdrawals. And I apologize if I didn't see this, but is there, was Mr. Piankowski aware of the withdrawals being recorded in the cash room?
I believe yes. I think it was signed pieces, the withdrawals were signed or recorded. Now, I don't know the specific nature of the recording, but it was recorded, and I believe he knew that.
And as I understand it, the purpose of the letter to the letter from the auditors to Mr. Fulton and Mr. Ross was somewhat of an effort to make them aware of the situation, or aware of the withdrawals, and ask for guidance on treatment of the withdrawals financially, or from an accounting standpoint.
Yeah, that, again, and it was they were making this from an accounting perspective, and so when we talk about withdrawals specifically, the letter talks about advances, so the nature and the methodology, I don't believe that's what they were doing. They were saying, how are we treating this thing that sits on your balance sheet? And so their question, again, purely from an audit function was, how are we classifying this due to, due from? Just by way of example, as we were constructing our garage, the advances that came from Mr. Fulton to fund that also were due from.
The question, or the letter we have in front of us, Exhibit 5, I'm curious, it's addressed to Mr. Fulton and Mr. Ross, and appears signed by them on the bottom, but it's also signed by Mr. Piankowski. Why, any idea why he would sign off on the letter as well? It's not addressed to him.
He was the manager. He was the president and manager. So and Mr. Fulton and Mr. Ross signed off on it as investors, but they had no formal oversight or function within the organization. The only person who had that was Mr. Piantowski.
But yet, he's not addressed at the top of the letter.
That's correct.
Thank you. Anything else? I just have one more. An important part of what you are saying to us, I think, is the nature of the clean break between the systems under the prior president and the systems going forward, and who was accountable under the prior president and who was accountable going forward. And I want to read from page 38 of the redacted report. During Ross's, this is the bottom paragraph at the bottom of page 38. During Ross's interview, this is the interview with member Ross, he stated that he realized there was a need for better internal controls and that he also realized that there had been too much control vested in Piantowski. Ross also stated that Grogan had been engaged by Piantowski in 2009 when the applicant began exploring proposed expansion of its operation into gaming, and that he was confident that Grogan would put immediate measures in place to improve the corporate governance and internal control environment of the applicant. Were you able to do that?
Yes, I mean,
Well, this was 2000 and,
No,
he's
no,
talking about 2009,
during Mr. Ross's interview, which was on April 4th.
right?
So he said he was confident that now, as president, that he was confident that I could do that. So he was expressing confidence that I would be able to do that starting April 4th, moving forward. Right?
Okay, I read that to mean that Mr. Ross was thinking when you first came in
No,
that
no, no.
you would.
It said during Ross's interview.
Yeah, I know it's during Ross's interview. All right, I mean, I guess you can
So
read it.
saying I started in 2009, which was I had some familiarity with the business. And so that was how I met Mr. Ross. I did not know Mr. Ross before 2009. So I think I think that statement was simply saying that he was confident that the internal control plan, which you see, which was my April 4th document, he was comfortable that I could do that.
Yeah, I understand. I thought he was saying that earlier.
No.
Do we have your consulting contract? The original contract that was in place when you first came on board in 2009?
There was no written contract.
There was no written contract.
I was paid by the hour.
Out of the money room?
Yeah, I would never have accepted it if it were coming from the money room.
Was there any documentation of what your tasks were, what your priorities were?
No. I was a consultant, paid by the hour.
Okay, no deliverables, no nothing.
Correct.
Okay. Go ahead, I'm done, I'm finished.
Okay, just so since the departure of Mr. Peterson, I trust you're thinking about replacing him. Are you thinking of a CIO position, CFO position, or a controller, like he was characterized?
So we have an immediate issue around a controller function, and as we've said, we're looking for a CFO of Plainridge, what we call Plainridge Park. If we receive a Category 2 license, we'd do that upon the receipt of the Category 2. Now we're looking for a controller type position.
Okay, there's an opportunity, anything else, commissioners? There's an opportunity for the applicant for a redirect, if you wish.
Just a few questions, members of the commission. First of all, as to the IGT matter that is the subject of some questions, is there an assumption on the part of Arrowway that there may be some dispute regarding that document and as to the rights of IGT?
I'm sorry, is that a question?
That's a question.
I'm sorry, question, I'm sorry, you're redirecting the question.
Is there an assumption that there is in fact a dispute between Arrowway and IGT as to the meaning of the agreement and
Yes.
the consequences of a potential set of rights in IGT.
Yes, I think it's fair to say we have different views of what that document is.
And in any event, in terms of the financial terms that appear to be reflected in that document, are they favorable or unfavorable, in your view, to Arroway?
We view them as very favorable to us.
And do you understand that if, in fact, it comes to pass that IGT is operating the casino, that there would be some obligation to come back before the commission relative to relative to IGT's
Yes, yeah.
background?
We understand that additional qualifiers, additional vendors, anybody who can influence the operations of our business needs to be found suitable before the commission, before they could take on any of those functions,
And
positions.
And has there begun to be some communications between Arroway and IGT regarding this document?
There have been discussions, yes.
There were questions, I believe, from Commissioner Zuniga regarding your role as president and whether it differed very much from the authority that was placed in the former president. And what I want to ask you is, do you have full authority to do anything you wish to do regarding the operation of Arroway?
No, I do not. In the more recent document, the July 17th one, limits or discusses the limits that I have in terms of material contracts, in terms of material hires, in what needs to be reviewed by the CEO before I can do that. So there are fairly well described limits to what I can and cannot do.
And have you had any conversation with Mr. Fulton as to how active a role he expects to play as CEO?
Yes, he is going to be very active. It's in terms of moving forward, it's his experience, and again, I am excited to be working directly for Mr. Fulton. He has a spectacular background in the gaming business and the casino operations business, and that expertise and experience is going to be invaluable as we move forward. And lots and lots of, and he has lots of experience and lots of opinions about how we should move forward.
And finally, relative to the resignation and departure of the former president, was there a complete disclosure by Arroway regarding the terms and reasons and rationale for that parting of the ways?
Yes, to the IEB.
To the IEB?
Absolutely. All of those, the documents, the reasoning, what we did, how it was done, all the documents were sent to them. We understand our reporting obligation to them when we're in there, and fully disclosed all of it. And as going back to that particular day, I got that job at 5. We sent the documents into the IEB, and I got a call at 8 o'clock that night. So they understood. And again, the following day, just in terms of thinking of sequence, I got the job at 5 o'clock. At 11 a.m. the next day, I was testifying to the investigators.
That's all I have.
Could I just follow up on that last question? When you gave that answer, Mr. Grogan, were you aware of whether or not any of the higher level Arroway members who were interviewed by the IEB said that the reason for Mr. Pointoski's departure was health reasons?
No.
Opportunity for cross? Recross?
No further questions. We do have 2 additional exhibits to introduce. I think that the applicant is agreeable to the introduction of both of these. One is the 2008 document that we referenced during the cross-examination of Mr. Grogan, and the other is the quite recent July 17th, 2003 appointment of officers document reflecting the appointment of Mr. Fulton. And as I say, unless the applicant has objections, we're prepared to hand these to the
No objection.
Okay. All right. Any other commissioner questions? So we're all set. Thank you very much, Mr. Grogan. We appreciate it. We have one more witness, Mr. Fulton. I would like to suggest a very quick 5-minute break, and then we'll settle in and try to get this done. Ladies and gentlemen, I think we're ready to start again. We have one more witness. I believe that's right. Mr. Richland, you have one more witness, right?
I do. You know,
Just before you go into that, the question was you have one, right? No more than one.
well,
Oh, okay.
and I do want to address that because
Okay.
it's been communicated to me that there's been a request for an additional witness. And Mr. Mackey and I have discussed that. As the commission knows, I had originally identified potential witnesses. They included Mr. Ross. In preparing and in the last week to 10 days, I've made the determination that his testimony would be largely corroborative and cumulative, and in the interest of both time and other interests, I thought we would offer just the witnesses that we have. If the commission has an interest in hearing from anybody that's in this room, we're going to make them available to you. So I would say that it appears that we will have a second witness. We'll have Mr. Fulton and then Mr. Ross, again, if that's the wish of the commission.
Okay. Well, I was raising this mostly just to give the audience a heads up about our schedule and
Yes.
plan, but, so you've suggested that Mr. Ross
If the-
testify?
If the commission feels that it would help round out the record based on some of the particular questions that have been asked by commissioners, we obviously would, I assume that Mr. Richland would want to ask him a few questions. We would ask very few questions on cross.
Okay.
But if it would be helpful to the commission, that's,
Okay, so let's wait until the end of this, see where we are, and so there's at least one more, there may be another. So we will reconvene our suitability adjudicatory hearing on the application of Our Way Realty LLC, and ask Councilor Richland to begin the direct examination.
Thank you. Sir, would you please state your full name?
Stanley E. Fulton.
Mr. Fulton, where do you reside?
I reside in Las Vegas, Nevada.
And, sir, do you have an affiliation with the company Our Way Realty, the applicant for the license that issued you?
I have for approximately 12 years.
And what's your affiliation?
I was a passive investor.
Has that recently changed?
It has.
And what's your role today?
I am the CEO, and I'll be an active CEO.
Now, sir, could you briefly give a summary of your background in the gaming industry? And I know it's a long history, but I would ask you to give us the highlights.
I'll be brief. I got my first gaming license in I think it was 1976. Yeah. And my company back then, I say my company, I owned 80% of it, my sister owned 10%, my accountant owned 10%. My company back then was Fortune Coin in the division of K-Tech, but we built the first video slot machines, multi-line video slot machines. We built the first poker machines back in 1977, I guess. A brief story concerning the poker machine, I'll be very brief. We reprogrammed our multi-line video slot machine to make it a poker machine. And the Nevada Gaming Control Board had one employee back then, his name was Paul Brugger. And my general manager wrote Paul a letter and saying, "Dear Paul, we've reprogrammed our multi-line video slot machine for a poker machine. All in favor of this machine for use in Nevada, raise your hand and say aye." We got back from Paul a handprint on a fax. And it said, "Aye, Paul Brugger." That was the approval process for poker in the state of Nevada in 1977.
Now, Mr. And I take it you've been involved in gaming matters since then?
Oh, absolutely. I mean, through numerous companies. Boy,
Well, let me ask a question to bring it forward. We know you have a relationship to Sunland Park in New Mexico, is that right?
that is correct.
And could you describe the kinds of activities that occur at Sunland?
Well, we have got like 1,700, approximately 1,700 stalls for racehorses. We have one race, it's a Derby prep race for $800,000. Our purses between quarter horse and thoroughbred usually run around $250,000 a day. It would be closed, but for one simple reason. We're allowed to have some slot machines, and they pay the bills.
And what role do you play at Sunland?
I'm the owner.
And do you have some active engagement there?
I'm talking with the managers all the time concerning what is happening and why is it happening. And
you obviously heard Director Wells describe some of the conclusions she heard regarding the quality of the operations at Sunland. And you also heard her describe the regulatory interactions that New Mexico authorities had with Sunland. Can you describe the standards that you set for that operation?
pardon me, 5 violations in 5 years, and 3 of them we blew the whistle on ourselves. And the other 2 were sting operations by the alcohol division down there. No one has a record equal to that or better than that, period, in my opinion. We have a record of compliance and cooperation. I'm very proud of our record. But here again, I've operated casinos before through Anchor Gaming and routes and built machines and invented machines. And I've been very, very active in the gaming industry since 1976, actually 75 when we started designing and trying to build the first multi-line video slot machines.
Now, Mr. Fulton, you heard the question that was asked by Chairman Crosby about to Mr. Grogan about his level of experience and ability on an operating level to run our way and to have it achieve some of its objectives, both in terms of compliance and also in terms of growth and building the company out. Do you have any doubts about Mr. Grogan's ability to accomplish the tasks before him?
Absolutely none whatsoever.
And why not?
He's brilliant, just real simple. Not only that, he's a nice guy. But let me tell you my thoughts concerning business. Business is 2 things, in my opinion: numbers and people. If the numbers are right, then the next job is to get the right people to make the numbers work. Now, we've started, pardon me, Our Way is a new company, effective with the departure of the former president. John will have a great slot manager. You'll have his HR. You build a team, and that's what we will do. And it'll be a team that'll make Massachusetts proud with the fact that they awarded the license to Plain Ridge.
And sir, with respect to your business experience, particularly in gaming, have you built such teams in the past?
Oh, absolutely. I mean, in numerous companies. It's numbers and people. Now, you know the numbers are right for a slot license for Plain Ridge. I mean, I describe Plain Ridge as the shortstop. We're going to shortstop money from, the Massachusetts money from leaving the state to go dump it in machines somewhere else.
Now, sir, you know from listening to the testimony and the questions today that the commission has been interested in the events that involve the former president and certain cash withdrawals that he made from the money room. And there is a document which has been admitted as an exhibit, and I'm not sure I have the
Number
mark.
5.
Number 5, so you remember better than I do. And I want to show you that document. And the first thing I want to ask you is that it appears to have, well, I guess first I'm going to ask you this. Do you recall that in the course of your initial interview that you were shown this document?
Yes, that's true.
And at that time, did you have any recollection of having seen this document before?
I think it's probably fair to say that the former president of our way was deceptive. If he put this in front of me and said, Al has already agreed to this, I would have signed it. Do I have any recollection of signing it? No, sir, I do not. Do I have any recollection of ever having seen it before it was shown to me? I do not. But I will tell you this. As a businessman, had I known of these withdrawals from the money room, they would never have been allowed to happen, period. And when I found out about them, I placed a call to the former president and made one simple statement. You took money that was not yours. Now, concerning his leaving, I believe it's, one commissioner was a Supreme Court justice? Is that?
Appellate court.
Huh?
Appellate court.
Appellate, anyway, appellate court, Your Honor.
Should have been the Supreme Court.
I agree with that.
So do some others.
I also was not happy with the severance agreement with the former president. But here again, as a businessman, I had to make a decision. Go through protracted litigation, which that was what it would have ended up at had we thrown him out the door. And a whole bunch of factors. And the decision was, we have to have a clean slate going forward. So I agree with you. I'm unhappy with it. But as a business decision, it had to be done. It just had to be done. And concerning the statements that he resigned for ill health, I don't make those statements. In fact, you can't believe press releases. I remember one press release that in the company that I headed, I just fired the guy. And the press release is we reluctantly accepted his resignation. Don't believe those press releases people put out, I'm sorry. And concerning the former CFO, I was part of that decision to accept his resignation. And the reason is real simple. Had we rewarded him with a one-year contract, the Massachusetts Gaming Commission could say, you're not cleaning house, which needs to be done. And we've been subject to immense criticism, and rightfully so. Have we rewarded him for his past? I'm sorry. The former CEO had a 30-year association with Al Ross,
Former CFO.
former CFO, I'm sorry, the former CFO. Thank you. A 30-year association where Al was responsible for the jobs this guy got. And he wouldn't report these irregularities to Al? No. We did the right thing in accepting his resignation. And if we had rewarded him, you'd have every right to criticize us.
Now, sir, just to complete a question, there is a signature line with your name and a signature that appears over that name. Is that your signature?
I think it is. Okay. I'm not a handwriting expert, but it sure does look like my signature.
And as you sit here now and look at this document, is there anything in the document that did disclose to you that the advances were obtained through daily withdrawals of cash from the money room?
Absolutely not. And like I said, had I known about these withdrawals, I'd never, ever would have allowed it to happen. You know, I had companies where I owned basically, I'm a family, 100% of. We had money rooms. I wasn't allowed to take a penny out of the money room. And when you run businesses, you don't allow that to happen.
Now, you know, of course, both from the report and from the questioning and testimony today, that this commission wants to know that the practices of the past are understood and won't happen again. What can you tell this commission in that regard?
I have immense confidence in John Grogan putting in place internally the controls necessary to clean up the mess that was there previously. And not only that, the report of the IEB mentions something about honesty. Well, I can honestly tell you that we're going to run the operation by the book. Now, let me say about running the operation by the book. I think there's been some, and I want to address, if I can, the IGT thing. I think there's been some misunderstanding. The intent of that agreement is real simple. The intent of the agreement calls for Anchor Coin and then Anchor Gaming and then IGT to operate the machines there. Now, as a matter of interest, the financial terms of that agreement are very, very bad for IGT.
Which means they were very bad for your company, Anchor Partners.
That is true. No, wait a second.
Anchor, whichever.
No, Anchor Coin.
Whichever.
Yeah, so it was very bad for Anchor Coin. The truth of the matter is, my guy messed up, okay? And George Chimento drafted a great contract for Plain Ridge. But he did it, and there it is. The intent was real clear. Now,
Could I just interrupt, excuse me?
Yes,
But
sir.
this strikes me as central. And I appreciate the passion with which you're speaking, and I absolutely appreciate the conviction with which you speak. But at the same time as you're telling us that you can assure us that things are going to be buttoned up in your new operation, you're telling us that your guy who signed a significant deal, a big deal, with Plainville, got snookered by somebody else and did a terrible deal. And that once again, you weren't paying attention to what was getting done.
here again, George drafted a great contract for Plain Ridge. It's very interesting, the council we had said he signed off on it. So he was snookered also. But my record is there for all to see of compliance and cooperation and building successful businesses and seeing that they're run right. But let me get back to the IGT thing if I can. So the intent is very clear, all right? The terms are bad for IGT now and good for Plain Ridge. Now, I've had meetings where Patty Hart said, yes, we're going to operate the machines. Here again,
And who's Patty Hart, just.
Patty Hart is the chairman and CEO of IGT. Here again, I don't think they want to operate the machines. So if they don't want to operate the machines and honor the agreement and the intent of the agreement, that's okay with me, but give me a little something to make this thing go away, or give our company something to make it go away. Now, unfortunately for us, we can do absolutely nothing until we're awarded the license for the 1,250 machines. And the reason we can do nothing is because the agreement says we have to be awarded the license first before basically this agreement takes effect. There's an arbitration clause in the agreement, and the arbitration clause calls for the arbitration to take place in Massachusetts. So, but I will also tell you this. As late as last week, I was contacted by someone from IGT we had a meeting scheduled for 11 o'clock Friday, but that conflicted with our advisory committee conference call. But he's the one that canceled it. He says, when I meet with you, I want to be sure that our CFO is with me also. So we're trying to resolve this, and it will be resolved, in my opinion.
Now, just to, because I'm not sure everyone heard what you said in response to a portion of the chairman's question about your responsibility for that agreement when you were at IGT. Did you have counsel who negotiated that agreement?
No, we did not.
Who negotiated with Mr. Chimento
A
on behalf of Plain Ridge?
gentleman by the name of Joe Murphy.
And what was his role in your organization at IGT?
He was in operations.
And was a lawyer involved on behalf of IGT?
IGT wasn't involved then, I'm sorry.
Oh, I'm sorry, it's Anchor Point.
Yeah, Anchor Point. No, it was not.
Okay, all right. But you relied on your director of operations?
Yes, that's true.
Okay, all right. Now, the commission has information, and there's been some testimony today that you've made a financial commitment to provide the funding necessary, 100% of the funding necessary to effectuate the new operation if the license is awarded. Is that correct?
That's true.
And how much is that commitment that you've made?
I believe the total commitment is around $160 million. But here again, I'm not sure that we can keep it at that. It might go to 200. I've got some really, I guess, constructive thoughts how that we could make the slot machine operation even better. That we'll talk about later. This is a suitability. This is not an operational meeting.
Sir, before you said that you've made your decisions in business based on numbers and people, and you are putting $160 million up, I presume, because you've evaluated that the numbers are good, is that right?
That's correct.
What about the people that you are investing in?
Here again, it's difficult for us today to like go out and hire a CFO of the caliber that we're going to have after we're awarded the slot license, because these people just don't want a 6-month job. Is what it boils down to. Even hiring a slot manager today, the guy doesn't want a 6-month job when he's not going to have a job if we're not awarded the license. You got to get the license before you can really truly build the team necessary to make the numbers work.
And what role does Mr. Grogan, in the fact that he's now agreed to serve as president and report to you as CEO, what role does his being available play in your willingness to make this investment?
Here again, John's brilliant, and he is instituting, and many of the controls have already been instituted that requested by the IEB. And while I'm at it, I want to thank the IEB for bringing to my attention in my interview the fact of these withdrawals that I knew nothing about. Absolutely knew nothing about.
That's all the questions I have. Thank you, Mr. Fuller.
Thank you, sir.
And then Mr. McNamee, any questions?
Oh,
Wow.
That was dramatic.
I'm happy to try to proceed in the dark, but it's going to make reference to the documents for Mr. Fulton a little challenging.
Mr. Fulton, right.
Storm out there?
Mr. Fulton gets the last word.
Right.
it's a light.
That was showstopper.
I think I have a flash there.
Good to go? Are you working?
Okay.
Okay.
Good afternoon, Mr. Fulton. Just a very few questions for you. First of all, do you, Mr. Richland, could you hand Mr. Fulton what's now been marked as exhibit number 7, which is the 2008 letter from the accounting firm? Do you have that handy? And Mr. Fulton, just to put it in context, this is the letter referenced in Mr. Grogan's testimony, which references certain advances, is the word used by Mr. Piantowski from the company. Specifically, well, let me ask you, have you ever seen this letter before today?
I don't think so, sir, because among other things, I see my signature isn't on the paper.
That's right. It appears to be signed by Mr. Tuck and Mr. Ross, but it does not appear to be signed by you. And you don't have any present recollection here today of ever seeing this letter.
That is correct, sir.
Okay. Now I note on the third paragraph on the first page, there is a reference, as I indicated, to certain advances. And let me just read into the record 2 sentences. Through June 2008, Gary has received advances from the company net totaling $488,088. Gary is presently having payroll withholdings to repay certain credit card charges. The amount, which is approximately $450,000 through December 31st, 2007, is made up of various transactions, some of which are certain note agreements between he and the ownership group, originally totaling $156,800. So as I read that, does that refresh your recollection at all about whether you've seen this?
Absolutely, it does not, sir.
Okay.
One thing did occur, is that I believe Al and I sold Gary some stock at one time. It's very possible that 156 is referring to that, but I don't know.
That might be that loan agreement
That
that's
might be-
referencing to.
that might be this thing, sir, but I can't swear to it.
Okay. Now, I take it, Mr. Fulton, from your earlier testimony, that if this letter had said that part of this amount was made up of cash withdrawals from the money room, that would have gotten your attention.
As a businessman, I would never have allowed this to happen.
If you had seen that in this letter, you would have put a stop to it.
Absolutely, sir.
The exhibit number 5, which is the 2012 letter, similar letter from the accountants. Do you have a copy of that one handy, sir?
I have it.
I just want to make sure that your previous testimony for the record is clear. You said something, and please correct me if I don't have this right, that if you had understood at the time you saw this that Mr. Ross had approved it, then you would have signed it? Some
Pardon me?
words to that effect?
I think my words were, the former president of the company was deceptive. I believe everyone has to agree to that, all right? And I think he pulled a fast one on this one. Maybe having told me, I'll approve this sign here.
But you don't, as you sit here today, you don't have a specific recollection of a conversation with Mr. Ross. That's really what I'm asking.
Absolutely, sir. I do not have any.
You do not.
Thank you, sir.
Now, I understand the first that you learned about these withdrawals from the money room was when you had your sworn interview with the investigative team here. And then it sounds like promptly after that you put in a call to Mr. Piankowski.
The phone records would prove that to be true.
Okay. And you said something like you're taking money that's not yours.
I believe those are my exact words, sir.
Okay. Can you tell us what Mr. Piankowski said?
He disagreed with me.
Okay. Do you recall anything more specific than that?
I'm trying to think, sir. I don't know, but at that point in time, I knew what had to transpire.
I have no further questions. Oh. Pardon me. With respect to the gaming operations that will occur if our way is awarded the Category 2 license, is it your intention as the head of the company that Mr. Grogan will have direct operational responsibility for that gaming activity?
Pardon me, he will have a team of people reporting to him.
Okay. And also, so the record's clear, IGT, been a lot of testimony about IGT and their potential role going forward. Are they in the business of operating casinos?
No.
Do they have experience
Pardon
with
me,
that?
at the time that agreement was signed, it was signed by Anchor Coin, and Anchor Coin operated casinos and machines throughout Nevada. But after then Anchor Coin became Anchor Gaming, it was later merged into IGT. And the first thing IGT did was sell off the casinos, sell off the route, divest itself of all the parts of Powerhouse, which we had acquired for $290 million. Oh, everything but Sunland Park, because when I left the company, I said, I want something to do. I want to watch your ponies run, hand out some trophies. And part of the deal is I want to take Sunland Park with me. And also the investment in Plain Ridge. I think along the line someone asked me if I was ever going to buy any racehorses, and I said, no, I'm too smart for that. But I proved that to be false. okay, because I ended up buying a bunch of racehorses, thoroughbreds, and that's God's way of telling you, you've got too much money.
Okay. On that note, I will conclude my questioning.
Question?
Yes,
Mr.
go ahead.
Fulton,
Yes, ma'am.
it's apparent that you were angry when you found out that Mr. Piankowski was taking these disbursements. Did you ever consider criminal prosecution? I mean, we're talking about six-figure numbers here.
I think to say that I was angry is an understatement, ma'am. I have great confidence in John and his ability, all right? And John thought it was best, and I agreed with him, to rapidly put a closure to the former president and our association. There would have been, in my opinion, protracted and expensive litigation, and it would have been extremely harmful to the company. We did, from a business decision, we did what was right.
When you say litigation, I don't frankly see what litigation the former president could have brought, knowing you had this information and there was proof of this, these distributions that were not known to the managers, the investors.
I'm not a lawyer, but I do know this about the law. Anybody can sue anybody about anything. And I ought to know because I was sued by trial lawyers out of, I believe they were out of Dallas, because of a loan that I was repaid. And they were suing me for $6,750,000, plus legal fees, et cetera, et cetera, et cetera. That particular lawsuit cost me $1,200,000 in legal fees, and that was before pre-trial motions, the trial, or the appeals. And I was told that that would cost me the $2 million. And finally I said, all right, go to those lawyers and offer them $300,000, but they've got to give me a letter that I did absolutely nothing wrong. And those trial attorneys said, he wants a letter like that? No problem, no problem, just give us $300,000. I'm sorry, it would have been expensive, ma'am. It would have been protracted. It would have been horrible.
Okay, I think I misspoke. It was 7 figures we're talking about. And the other question I wanted to ask you about was the letter that, has been brought into evidence that you claim that you are not aware, you don't recall signing it. Do you think this is something, I'm
Exhibit
talking
5.
about exhibit, yes.
5.
Yes, correct. Exhibit 5. Do you, what's your understanding of, you believe Mr. Piankowski got you to sign this letter without your knowledge of the content? Is that, I was trying to understand from your statements.
Pardon me, that's, I believe, probably the case, sir, ma'am.
Okay.
Again, I think it's very evident that everyone is agreement that the former president was deceptive. Period.
Could I just pick up on that, Mr. Fulton, sticking with Exhibit 5, and I have very few questions, but Exhibit 5 does talk, you'll agree, about a large sum of money.
Yes, sir, it does.
Yes. And it talks about an advance to Mr. Piankowski of a large sum of money.
As I said, sir, I don't ever recall having,
Well, I know, but as you read it now, and if your signatures, well, was it your practice to sign documents then without reading them?
probably because of the trust factor, yes. And if he had said, Al had approved of this, I would have signed it.
So if you trust somebody, is that still your practice today?
Let's say, my trusting bones have not been broken.
All right. So that if you have full trust in somebody today, you're likely to sign documents that they ask you
Here
to sign.
again, let's
Pardon me?
talk about, pardon me, sir, let's talk about my relationship with John Grogan, okay? I have every confidence in his doing what's right for the Massachusetts Gaming Commission. And I have that confidence in John Grogan.
And that's admirable, sir. But you once had that confidence in Mr. Piantowski, did you not?
I was snowed, sir.
All right. Would you describe what you envision your role as the CEO of Our Way to be?
Okay, I think that I'll be in constant contact with John concerning what is happening and why it is happening, all right? And then hopefully providing some direction concerning some positive developments to make the slot parlor even better for the state of Massachusetts. I like me, who do you like? But I've got the ability to do it, sir, and I'll use that ability for the benefit of the people in the state of Massachusetts.
All right, sir. Let me ask you one final couple of questions. You have a substantial amount invested in the Our Way operation over
Yes,
the
sir.
years. And did you did you have any role in selecting an auditor for the Our Way operations?
No, sir.
Were you interested in the quality of the auditor?
I think the auditor let us down, sir.
Were you
I think that the auditor should have contacted Al, at least.
As an investor who was putting up millions of dollars for this operation, did you have an interest in seeing to it that there was some oversight from an auditor of the way the monies were being expended?
I'm not quite certain that I understand where we're going with this.
Well, just-
I have
I
three
don't know where we're
children
going
that
either.
are, I have three children that are CPAs, okay? One has an advanced degree in taxation called an LM. You've got to trust people, okay? And you trust your auditors, okay, to give you the straight poop and you know? And evidently that didn't happen here.
Did you read the annual audit report? Were there annual audit reports?
Probably
that-
not, sir.
Pardon me?
I said probably not.
Do you recall, so you don't recall reading any annual audit reports of Our Way operations?
I do not recall, sir.
You'd invested over the years, is it fair to say, around $30 million or so in Our Way?
I think it's a bit more than that, sir.
And you didn't read annual audit reports?
No, sir.
All right, thank you.
Just to pick up on something about the audits, and I noticed that Exhibit 7 is from one audit firm, Husted and Husted, CPAs. That was in 2008. 2012, the letter is from another set of auditors, Gosul, Butkus, and Jessen. Do you recall as to why maybe there was a change in these firms,
No, sir, I do
Or-
not.
or when that happened? Obviously,
No, sir, I do
between
not have any knowledge whatsoever of that.
Who decided to pick the auditor?
Probably
Who-
Gary.
Gary may have been
Pardon me,
Mr.
sorry,
Pinkowski.
former president.
You can say his name.
Thank you.
Anything else? Commissioner Stebbins?
You've talked a little bit about the regulatory compliance success you've had with Sunland.
Yes, sir.
and other than the fact you bought some horses, describe for me, if you can, a little bit more about your role in kind of day-to-day operations at Sunland, or to the extent of your role at Sunlight.
Well, typical would be, on a trip to Sunland Park, I was talking with Harold Payne, the manager, and I'd just been given the CapEx budget. And I said, Harold, I noticed that in the casino, because you're allowed to smoke in casinos down there, we have our casino in two different sections, one for non-smokers, one for smokers. In the smoking area, I call them smoke eaters. These are the devices that purify the air. You've only got 2 new ones being in the CapEx. And you might consider increasing that number to make the air cleaner. And he says, it's not a bad idea. I'll give it some thought. And I returned maybe 3 or 4 weeks later, and I said, Harold, I know you always wait till the end of the racing season before you start your CapEx, but you might consider doing this early because it doesn't interfere with the racing. And he looked at me and he said, the ductwork is in, the electrical is in, they're being installed Monday. You see, my type of man is a do it right now type of person. Okay? And I think John Grogan is that type of man. And that's the type of people I want to be associated with.
And I mean, that's a pretty hands-on anecdote you just shared. You referenced earlier that if Sunland did not have the slots parlor, I'm assuming revenues are on a downward trend for just
It would
track
have
operations
been
and the track
closed
revenue.
years ago, sir.
Okay. And over the past, just a 5-year window, what has Sunland's revenues done in terms of growth?
Pardon me, we have a little thing called a recession, and it has
Go a little bit farther out than 07, 08 if you want to.
well, it has affected the win per machine.
Okay.
It has affected the win per machine.
Okay.
Sunland Park was a great, profit center, all right? It's not great anymore, but it's pretty dead blame good.
So I guess one thing that struck me is that in the material, there isn't going to be any official relationship between Sunland and Our Way or the Plain Ridge course. But it would seem to me there seems to be some significant expertise that you could draw on to help support Mr. Grogan as he kind of comes up to speed in gaming operations.
That is true, sir. Actually, the manager we have right now was a key member of the management team for Penn National in New Mexico. And we hired him when Harold decided he wanted to retire. His name is Rick Ball, by the way.
Okay.
Very, very good manager, in my opinion.
So you don't see any kind of sharing of resources or expertise
It's
between the
possible,
operations?
sir, especially in things like marketing, advertising, things like that.
Okay.
The operation of the slot club.
In your new role as CEO of Our Way, what level of involvement do you see yourself in the hiring and firing, or will it be, again, kind of sharing advice and counsel?
Concerning the casino manager, which is a key person, okay?
Mhm.
I think I'm going to have a lot to say about that. Maybe like 99 and 44 100%. because it's a key position that's going to be reporting to John, okay? And it's will be part of his team, but it's got to be the right guy. I've got people standing in the wings begging to come on board.
Thank you.
I just have one question, which is something similar to what Commissioner McHugh asked. Your primary assurance to us that things will be different going forward, that things will be first class going forward, is your tremendous confidence and trust in John Grogan. Prior to the IEB report, did you have similar confidence and trust in Gary Piankowski?
During my interview by the IEB, I was asked the question concerning the former president and his business abilities. And I believe my transcript is very clear. I said, he's not a businessman, he's a politician. I recognized that Gary was not a businessman. I also recognized that what he was, and that was a politician. And there was no thought about him running the business going forward. Because he wasn't a businessman, sir. He was a politician.
But even as a politician, you had tremendous confidence and trust in him for what he was doing for you at that point.
One of the reasons that you have I'm going to call it Racino. Geez, that's a slot machine or racetrack, okay? But anyway, pardon me, you have a slot parlor, okay? I'll call it a slot parlor. Is, I believe because of Gary's efforts. But there's one other thing I got to say. I was described as a non-resident CEO. That's true. Most of your CEOs are going to be non-resident. But one thing I have done, I've put my money here in the state of Massachusetts to create jobs and keep a business open, all right? Just like Al Ross and our other investors. I might live in Nevada, but sir, I'm no carpetbagger. I'm no carpetbagger. I didn't come in here at the last moment saying I'm going to put up a box and 1,250 machines in. We're keeping a business going that directly and indirectly provides the revenue, the income for hundreds of people. And we're proud of it. And we've done it for a lot of years at great personal cost.
Okay, thank you. Other
Just a few questions. I just want to follow up on this idea that that you had confidence in Mr. Piankowski and you've got confidence in Mr. Grogan. Is there anything different? And so I would ask you, is everything the same at Plain Ridge today as it was before April 3rd, 2013?
It's like white and black. Pardon me. I told you that Gary was no businessman. John Grogan is a businessman that understands finances, okay? And doing what's necessary to straighten out what was a mess. But this is a new company going forward.
Now, Mr. Fulton, we've heard that Mr. Piankowski served as both manager and president at the same time. Does Mr. Grogan have both titles?
No.
You were at a meeting of the Board of Advisors or participated in the Board of Advisors meeting just recently on, I think, Friday, July 19th. Did you receive any information or materials in advance of that meeting?
Of course. Do you have a copy of it? It's like a book like this.
And sir, at any time during Mr. Piankowski's tenure, had you
Never.
received information of that nature?
I anticipated the question. Never.
That's
pardon me, it's a different company today.
And was there, before April 3rd, 2013, a board of advisors?
There was no board of advisors. By the way, concerning this board of advisors, my description of it, it's a bunch of heavyweights. You know, Mark Levine, he's more New England than he is D.C. He lived in Connecticut. He funded businesses here, and a lot of them went to northwestern, northeast? Anyway, right here, you know. Immensely talented individual. Al Ross, been in this business forever. I'm not chopped liver. And then we have good, great.
Neither chopped liver nor carpetbagger. We are on notice.
Message received.
Right.
And then the gentleman that John has gotten to assist us in this independent auditor, this guy's a heavyweight. Oh, I'm really thrilled to be associated with these people. That's how I feel about it.
Anything else? Counselor?
Nothing further.
Anybody else? Thank you very much, Mr. Fulton.
Thank you.
Appreciate your time,
Thank you.
your
It's a
enthusiasm.
pleasure to be here with you. And as a businessman, Mr. Chairman, you wouldn't have allowed it to happen, either of those withdrawals.
You bet you're right. Thank you.
Thank you.
All right, do we want Mr. Ross, who is willing, I'm hearing nodding heads, we'll take, why don't we do the same thing, let's take about a 5-minute break, just to give everybody a chance to get organized, and we will convene again with Mr. Ross. We will reconvene the adjudicatory hearing on the application of Our Way Realty LLC. We have a further witness, Mr. Al Ross. Mr. Ross, I don't think you were sworn in when we did the swearing in earlier. If you would please stand and raise your right hand. You solemnly swear that the testimony you will provide before the commission at this proceeding will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. He has responded in the affirmative. So let's start with as much direct as you wish.
Thank you, Mr. Chairman. Would you please state your name, sir?
Alfred Ross,
Mr. Ross, where do you reside?
Dartmouth, Massachusetts.
And how long have you resided in the Commonwealth of Massachusetts, sir?
Since 1931.
Would that be the year of your birth?
Yes.
Okay, so your entire life. Sir, have you ever served in the military?
Yes, I spent 4 years in the Navy, 1951 through 1955.
And you have an affiliation with the applicant Our Way Realty?
Yes, I do.
And what is that affiliation?
As a passive investor,
And when did you become a passive investor in Our Way?
right from the very outset, I made it known that I had divested myself of the racetracks that I had in 1989. I wasn't, chose not to be an active participant in management, and told all involved that my investment was passive.
And when you say a passive investment, can you explain what you expected your role to be relative to the day-to-day operations of the race course?
I had no intentions of being involved in the day-to-day operations at all. I was available on occasion and made it clear to the previous manager that because of the fact I had run racetracks for many years in many parts of the country, that if you have any questions, please feel free to call. And on many occasions in driving into the racetrack, if I felt something was in need of change, I would make a suggestion, and that was as far as my role was concerned.
And since April 3rd, 2013, you have assumed the role of manager of Arrowway Realty, is that correct?
That's correct.
And what do you understand to be your responsibilities in that capacity?
Mostly as a representative of the investors in ROA and conferring when needed with the president of the racetrack, whether by email or by phone or on the occasions when I am at the track to assist in any way I can. Be a part of the newly formed committee that is to meet on a quarterly basis and review the operation and make suggestions as needed.
And before Mr. Fulton became the CEO, which was formalized sometime in July, was there a reporting relationship between you and Mr. Grogan?
Yes. With Mr. Fulton being a couple of thousand miles away and being the lead investor, I sort of was a conduit between the two. If they had not talked for some time and fielded questions and inquiries from John and would confer with Stan on occasion as to what was going on and what was happening in the state. And again, made it clear to John that if at any time he had any problems not being familiar with pari-mutuels or harness racing, to feel free to call on me. There are two parts of that operation, one being pari-mutuels and the other being the racing that takes place on the track. And there's a big separation between the two. John had no idea whatever of what was going on the racetrack, and probably to this day, even being around there for 3 months, still hasn't got much of an idea of what's going on when the horses are going around the racetrack. That part of the operation has for 13 years been exemplary. It's run by professionals. We have had very few problems under adverse conditions, those being minimal purses and a shortage of horses. Because of minimal purses, they have done an outstanding job in presenting full field betting cards for the public, and the sport is almost relatively free of scandal at the racetrack. In fact, there has been none. Very minor violations here and there, which is commonplace at racetracks, but it's a part of the operation that Mr. Grogan doesn't have to pay any attention to at all. It's well-handed. He's got the other side of the operation, that being pari-mutuels, and where most of the employees are. And he's done an outstanding job in the brief period of time that he's been aboard.
Now, you know that throughout the proceedings today, we've spent a fair amount of time discussing the cash withdrawals that Mr. Pinkowski received while he served as president and manager. And there's been some discussion and testimony regarding a letter dated February 2012, Exhibit 5, and I want to show that to you. And the first question I have for you is, this document appears to bear your signature. Is that your signature, to the best of your knowledge and memory?
Those are my initials, yes.
Okay.
And I would have to say that they are mine.
Okay.
Yes, written by me, yes.
And do you have a recollection of having placed your initials on this document?
Not really. I look at it now, and I'm sure it was placed in front of me to get the signature. Way in the back of my mind, the only thing I can think of was when I looked at the numbers, it struck me as they were all inclusive of his salary, so that nothing jumped off the page to me, and I paid no more attention to it. As far as the frequency of cash withdrawals from the money room, I had no idea. whatever, of that occurring.
Now, I want to follow up on a couple of things you just said. First of all, do you now understand that the number reported as either advances or withdrawals was not inclusive of Mr. Piankowski's compensation?
Yes,
So this was money over and above. You understand?
yes,
that?
yes.
And as to the frequency of cash withdrawals, when did you learn that those withdrawals were made on a almost daily basis?
That would probably be after the IEB investigation in Las Vegas with Mr. Fulton. When John came back, he reported to me what took place out there, and that was part of the investigation, part of the queries of Mr. Fulton out there, so that I was made aware of it at that time.
And at that time, when you were made aware of it, were there some number of conversations between and among you, Mr. Grogan, and Mr. Fulton?
Yes,
And did those discussions involve whether, and if so, what steps you wanted to take relative to Mr. Piankowski's continued relationship with the company?
oh, it was generally agreed by the three of us that with the information that had been imparted to Mr. Fulton out in Las Vegas, that it would be best to terminate Mr. Piankowski, because going forward, it would jeopardize everything that we worked so hard for 13 years, and it was going to be a problem, and we wanted to basically get rid of the problem ASAP.
Now, you know that the company didn't terminate his employment. You didn't simply put him on the street, that in fact, a separation agreement was entered into between Our Way Realty and Mr. Piankowski. You know that?
Yes, I know that, and it was pretty obvious in talking with Mr. Piankowski at the time that he wasn't very interested in going forward any further and being interrogated by the IEB, and opted to resign.
Now, did you have any direct communications with Mr. Piankowski once you learned about the cash withdrawals?
No.
Now, do you recall that when his departure was announced, there were press reports to the effect that he left for health reasons? Do you recall that?
I recall that, yes.
Did he leave for health reasons, sir?
Not to my knowledge. I do know, and down through the years, he has had a heart problem, and whether he had any problems with his heart at this particular time, I can't say, but that's the only thing I know about his health situation, that he has had problems and gets EKGs frequently.
Now, Mr. Ross, the commission has asked for an attestation, a confirmation by Our Way officials and members that what happened in the past, and specifically with regard to the cash withdrawals and the absence of the kind of controls and oversight that allowed those to happen, that those things won't happen in the future. So what assurances can you offer to the commission in that regard?
Well, I guess the best thing that I could say is there's a new team in place going forward, and that lack of integrity is not in any one of our resumes. I know it's not in mine. I know it's not in Mr. Fulton's, and having worked with Mr. Grogan for 3 months, I know it's not in his. I know my record speaks for itself. I've never had a problem in the 45-odd years that I've been around the industry. I ran more racetracks at one time than anybody in the world, not that that means anything. I've got a sterling reputation. I was elected president of the American Greyhound Track Operators Association at a very tender age. Put into the Greyhound Hall of Fame, means nothing. I've got a sterling reputation, and lack of integrity cannot be attributed to me at all. And I feel the very same way about John Grogan and Stan Fulton.
That's all I have.
Just for the record, I would say that I don't think there's an issue here about the integrity of Al Ross or Stan Fulton. There may be questions about your oversight and the way you've executed some of your responsibilities, but there's nothing that we've seen or suggested that speaks to the issue of the integrity of these two men.
Thank you.
Do you have a, Ross?
Yes, Mr. Chairman, very briefly. Mr. Ross, you described yourself as a passive investor, correct? Would you have been in the habit of reviewing the audited annual financial statements for Arway as they were prepared by the outside auditors?
I briefed through them. I must say that reviewing a P&L statement and a balance sheet is not my long suit. I had very little college experience. I've been in the trenches all my life, traveling the world, trying to get permits for greyhound racing, states legalized and what have you. I always relied upon good accounting firms at the tracks I ran to do the books, and that's the best way I can answer your question.
Okay. I mean, it'd be fair to say that just even a quick glance at the financial statements would show that the company was being held up by financial infusions from the members, for the most
Yes.
part.
Yes.
So, do you recall, if you'd perused through the financial statements, any reference in those statements to distributions to members, money
No.
going the other way?
No.
Let me briefly show you exhibit number 7. Mr. Richland, do you have a copy of that? That's the 2008 letter. And if you could just turn to the second page of that from
Yes.
Mr. Ross. Does that appear to be your signature on the document?
Yes.
Okay. Do you, as you're, reading this letter now, have a recollection of seeing that letter, signing that letter any time in 2008?
Not really. Would you give me a chance just to brief through it?
Certainly.
I can't say honestly that I can remember very much about this.
Okay. Can you, you say not very much. Do you have any recollection of receiving or signing this letter?
No, I don't.
Okay. And so I take it you would, strike that. Exhibit number 5, that's the 2012 letter Mr. Richland showed you briefly. On this one, Mr. Ross, you said it appears to be your initials on the document.
That's correct.
Okay. Do you recall having any discussions with Mr. Fulton about this particular document, exhibit number 5, around the time that you signed it?
No, I did not. Mr. Fulton said that when the document was put in front of him and had my signature, I'm not so sure that this document wasn't put in front of me with Mr. Fulton's signature on it.
Okay.
But again, when I look at it, the only recall I have is I thought that these numbers were inclusive of his salary. I was incorrect in
Okay.
assuming that.
So, fair to say that, no recollection of Exhibit 7. With respect to Exhibit 5, maybe, a vague recollection, but no conversations with Mr.
Correct.
Fulton at the time.
Correct.
What about conversation with Mr. Piankowski on either document?
No, none.
Now, when you were, do you recall being interviewed by the Bureau staff in connection with this investigation back in April of 2013?
Yes.
And do you recall being asked about, at that time, about Mr. Piankowski's resignation?
Vaguely.
Okay. Do you recall telling the investigators, the representatives of the commission at that point, that you believed that Mr. Piankowski had resigned because of health reasons?
Yes.
Okay. And I think you testified earlier that that's not really why he resigned. Could you explain that?
At the time I said that, I might have been referring to press releases. I'm just not sure. But it was made clear that in a meeting in his office, I think John Grogan was present, and I'm not sure whether Mr. Fulton was on the phone. I don't think he was. But that there was going to be a big problem. Had he appeared in front of the IEB, and I remember telling him, I hope you pass with flying colors. I could tell from his reaction that he wasn't particularly interested in going that route. And he said, I believe he indicated he would resign at that time.
Okay. So this is a meeting between the time that Mr. Fulton learned through the investigation about the money room withdrawals and the time that you were interviewed by the commission.
Would you repeat that?
Sure. At some point, Mr. Fulton and Mr. Grogan learn about the money room withdrawals, and they're concerned about it.
Mm-hmm.
It sounds like following that time, there was a meeting involving yourself and Mr. Fulton, yourself and Mr. Grogan and Mr. Piankowski.
Mm-hmm.
And the discussion that you just had about Mr. Piankowski's reluctance to be in front of the Bureau, that's when that discussion took place.
Yes.
Okay. And then following that meeting was your interview with the Bureau staff? You have to answer.
Yes.
Okay. No further questions.
May I just pick up on that thread a minute? You were involved, as you've described, intimately in the discussions with Mr. Grogan, Mr. Fulton, and Mr. Piankowski about his resignation and his leaving the company, right?
Yes.
Okay. And you were interviewed by, and the reason that he left the company was that you three told him he had to leave, basically, right?
Would you repeat that, sir?
The reason he left the company is that the three of you basically told him he had to leave.
Yes.
And you were interviewed on the day, by the IEB, the day after he left.
Yes.
And you were asked by the IEB representatives who were there what was your understanding of why he left?
Well, as I recall at the time, I
No,
thought it
you
was a
just-
combination of
Yeah. go ahead.
his heart problems and I can't say whether it was up to me at that time to say that he had been fired. He hadn't been fired. It was suggested that he could not go forward with us, and he was not going to be a member of the team going forward, and he opted to go.
Did you tell the IEB representative that he had left for health reasons?
Well, perhaps I did.
When you looked at Exhibit 5, did you understand that, salary or not, the monies reflected on Exhibit 5 were coming from distributions from someplace?
No, I did not.
Were you aware that the same kind of distribution and the same kind of treatment of distributions occurred at the end of 2012, about 11 months after the date of Exhibit 5?
No.
You did not, if I understood your answers to earlier questions, read the annual audit reports either, is that right?
No, all the annual audit reports accompanied our application to the Racing Commission. We always got a clean bill of health from the Racing Commission. We're licensed every year, and my assumption was everything was fine as far as the audits were concerned.
Okay. So you didn't read them either?
No.
All right. Thank you, sir.
I have a question, Mr. Ross. What did you mean when you told Mr. Piankowski that you hoped he would pass with flying colors with the IEB?
He was concerned with what some of the questions might be, something to do with adopting a baby 2 or 3 years prior to that, and having some problems in the western part of the state with the adoption, and I was still, at the time, I was still hoping that, at that time, not knowing what I know now, I was still hoping that he would be a part of the team, so I wished him well.
Did you have that conversation with him after you knew about the disbursements?
No.
That was before. He was worried about the IEB interview before that came to light, that information.
He was worried before.
Before the information came to light in Mr. Fulton's interview, which was this disclosure of
Yeah.
these
Yeah.
disbursements, Mr. Piankowski was worried about the IEB interview?
No, it was after.
So after you knew about the disbursements, you told him you'd hoped he still could be part of the team and you wished him well?
I did not know of the disbursements, the frequency of the disbursements. And had I known at that time, I would not have wished him well. I still was hoping he was part of the team until a day or two after, when I learned more and more. And then I knew he could not continue with us.
Thank you.
Mr. Ross, the Exhibit 5, which has your initials, and Exhibit 7, which has your signature, looking at them side by side, they appear to have verbatim language. The first paragraph is identical in both letters. The closing paragraph is also identical. Stylistically, I would argue it may come from the same writer, but it's two different letterheads. One from Husted and Husted, and another one from Gosul, Botkas, and Jessen. Do you know whether somebody changed firms and continue to be your auditors in a different firm.
There are apparent, I did not check the letterheads and was not aware of the first paragraph being identical. No, I know nothing about that. I know there was a change of auditing firms, but I couldn't even tell you the name of the new one at that time. Name Husted and Husted rings a bell with me, yes.
Commissioner Stebbins?
Thank you. Two quick questions. I apologize if I'm asking this again, but Mr. Fulton was pretty passionate about his emotions when he heard about the distributions being taken. Can you share with us what your reaction was?
Very disturbed. Placed too much confidence in one person. Gave too much control to one person. This is all in hindsight, of course. Did not keep my left hand high. Feel I was misled on many occasions. And feel much more comfortable going forward with this new team in place than the one that was in place for 12 years.
You, I know you had a long relationship with Mr. Peterson going back a number of years. Did you ever get a sense that there was a workplace environment that, under the previous president, that I guess you would have been surprised by the fact that you didn't feel this gentleman who you'd known for so many years wouldn't have been able to approach you if he had a concern? Were you aware of that kind of workplace environment where he wouldn't have had that opportunity?
I can give you a brief history before I answer your question with Peterson. He started when he got married in South Dakota at a racetrack. I was running out there with my brother-in-law. He was newly married and worked as a mutual clerk, as did his wife. From there, we went down to Colorado and had a few racing seasons down there, and he wanted to know if they came down and vacationed in Colorado, could they both work as mutual clerks. The same thing happened when I came back to Massachusetts in the fall to run the Taunton Dog track. They were sort of on a mini honeymoon type of thing, and followed me back there working as a mutual clerk, both of them. It seemed as though everywhere I went, Peterson wanted to know whether there was a job for him. The same thing happened when I got racing legalized in Rhode Island in 1977. They came over there working as mutual clerks. He had an accounting background and moved into the accounting department and worked under Louis Reinbold, my CFO and CPA at the racetrack, and continued in that position up until the time we sold the racetrack in 1989. When I made the investment with Piantowski and Plainridge got off the ground in 1997, he asked me, were there any key employees that worked for me at Lincoln or Taunton that he could possibly use. I asked him in what category. One was money room. I gave him the name of a lady named Paula and her husband at the time who ran the money room for me at Lincoln, Tom Maldice. A girl who worked as a mutual clerk that was very sharp, issuing tickets, and Tim Peterson, who worked in the accounting department. He interviewed them, and as a result of that, hired Tim Peterson to come over and work in the accounting department at the racetrack. In my last sit-down with Tim Peterson, he expressed regret that he did not come to me directly. I told him I felt very hurt over his actions, so many years going by and keeping me in the dark. He said he tried to relay information back to me through a friend. Very weak way of trying to get something to me, but that's the way he attempted to do it. Never did get back to me. And came as kind of a surprise that in meeting, John and I meeting with him, we felt at the last meeting he was going to testify and make it known to the commission that if he stood in the way of our way going forward, getting a permit, he would resign rather than to see him being an obstacle. That changed in the last 72 hours, apparently.
Do you learn anything from that? Because it must be I understand this person was a friend for 30 or 40 years. You got multitudes of jobs. You know, looking back on that, does it say anything to you about your own judgment or management ability or practice or anything?
Well, he never worked for me in a real key position where I had to worry about that. His initial jobs were selling mutual tickets and what have you. My judgment, when you have thousands of people in your employ over the years, you make bad judgments here and there. I always prided myself in being able to read people. I missed badly with the former manager, and surely didn't see some of this weakness in Tim Peterson that I see now.
Anything else, Commissioner Stebbins?
Yeah, just one last one. Have you had any communications with the former president since he left?
None whatever.
All set, thank you. I had read earlier on something from the report about a comment that you made that I thought was saying that back in '09 or 2010, when Piankowski brought Grogan in, that at that point you were pleased because you thought that that Grogan would be able to improve the systems at that point. Did I read that wrong? Were you talking about, so you weren't, when he came in back in 2009, 2010, you did not have expectations that he would help button up the administrative and financial and operational
No,
systems?
that was not what he was hired for.
Okay.
He was hired, all right.
Okay. This is sort of beating a dead horse, but it's important, I think. When I said to Mr. Fulton about his tremendous trust and confidence in Mr. Grogan, and didn't he have the same trust and confidence in Mr. Piankowski, he said, in a sense, yes, but Piankowski was a politician, not a businessman. But this man, you entrusted him with upwards of $30–40 million of investment. He ran an operation with 140 people, a cash business, a highly regulated business. Why did you put a politician in charge of that operation and your $30–40 million?
Well, I really didn't classify him as a politician in my mind. His previous experience that I knew of was as of a racing commissioner and the manager of a harness track down the road that had to be closed because of some actions that Mr. Kraft took. So I didn't view him at that time as a politician. There was somebody that was knowledgeable about the racing game. From what I had garnered, had done a decent job at Foxborough, in running that racetrack, and felt that the game plan that he and a partner of his laid out to the investor group at one time was a sound plan, and that going forward that there was a possibility of running this track with simulcast wagering on a break-even basis, hoping that at some time we would get the aid of additional gaming. During that period of time, two things happened. One, the nature of the simulcasting business changed dramatically in that signals that we might have paid 2 or 3% for suddenly became 4 and 5%. And they were signals that we couldn't do without, such as the Kentucky Derby, Triple Crown, the Belmont. The tracks that had the good horses had all of the simulcast outlets at their mercy. So the nature of that game changed. It added to our losses. And a lot of the figures that we see in the loss column can be attributed to deferred interest. So that we did have a losing operation. We were intent on seeing the sport survive. We stuck with it for 13 years. With the aid of additional gaming, we'll be able to turn that around as New York and Pennsylvania and New Jersey and Delaware, Florida, Ohio have done. Something unique is happening, and please don't feel that I'm tooting my own horn when I say this, but a mass-bred harness horse, bred and raised in Massachusetts, is the lukewarm favorite to win the Hambletonian August 3rd. And not that that is my horse, or I'm the majority owner of the horse, but I just want to say that given a chance, the industry can take off and be what it was in the old Foxborough days from the 50s and 60s. We stuck with it. We kept a lot of people employed down through the years. We've got the horsemen on our side 100%. They know what we've been through. We've got the town of Plainville on our side 110%. They know the agony we have suffered down through the years, and thankfully for the investor group, Mr. Fulton, we're at the crossroads right now. We hope it is not all in vain. We hope that we can prove going forward. There's a new team in place, much unlike the team in the past, and I feel very confident going forward.
I just have one last question. When the decision was made, however it was made, to eliminate the prior president, bring in a new president and a new leadership team, at least a president, you could have done a number of things, including bring in the senior members of the Sunland team. You could have gone elsewhere. Instead, you chose to go with Mr. Grogan. How did you vet him? How did you come to the conclusion that he is the way, the truth, and the light that's going to bring you to success?
Because of the fact that he had been on board for 3 years and was fully aware of the operation in the 3 years that he was there, even though he was hired primarily to get our application in order. He's solely responsible for us getting it to the point it is now, and that appears to be far ahead of our competitors. We've got almost all our permitting in place. It just amazed me the speed at which he picked up the nature of the operation, the pari-mutuel business, and the protocols that he has put in place. It's so obvious in walking around the racetrack now and talking to employees and seeing floor managers in a uniform, seeing employees in a uniform, and knowing that, and they have said this to me, they know they can go to their department head now with a complaint or constructive idea, and not be threatened with loss of job or what have you, and in turn the department heads know that they have the same freedom with Mr. Grogan, and his staff meetings on a weekly basis bear that out. The change in attitude around the racetrack bears that out. There hasn't been one hiccup in the operation since he's come aboard. And I gotta say that outside of, I can't say he doesn't know which end of a horse eats, but he's not aware of what's going on in the racetrack at all.
All right, understood. All right, any further direct?
No, Chairman.
Further cross? Anybody else, commissioners? Mr. Ross, thank you very much. Appreciate your time for being here such a long time, and we will be talking to you further.
Enjoyed it, thank you.
We will offer the applicant an opportunity to make a closing statement if a representative wants to.
Mr. Grogan will do that, and if I could just have a moment to confer with my colleague.
Sure.
Good afternoon again. Before I summarize, I would like, if I could, digress a little bit and just talk briefly around some of the questions as it relates to my capabilities as president. Mr. Ross just came up with a new one, which is I didn't know which end of the horse ate. I have been accused of not knowing which way around the course the horses run. And some of those questions were about what do I know about gaming. The important thing that I think that I bring to this organization is a management skill. Well, I may not know which end of the horse eats or which way they go around the track. I'm comfortable managing an organization that has people in place that do that. So can I manage a harness, live harness racing and simulcast with the appropriate people in place? In fact, I think I can. And do I think I can manage a gaming operation when we have first-class people in gaming ops, security and surveillance, human resources, and the like? I do believe I can. And I want to come back and just for a moment address this question of trust. And you asked that question, which is the former president was trusted. And you hear from both the chairman and the CEO that they do trust me. Well, I'll say I work hard to engender that trust. To borrow a line from our former president of the country, this is one of those trust but verify. I don't want this to be that they trust me. I want them to trust me, but the institution and the organization needs to verify that that is in fact there, so that this is never going to be an organization built around one, but built around a system of moving forward. And so that system of, and we'll touch on that, and so, while I don't know which, well, I do know which end of the horse eats, I am comfortable running that business. But now, we can come back, well, I'll leave that as it is. In summary, we understand that we need to establish by clear and convincing evidence that we're qualified for licensure. We have endeavored to do that today, and I understand under some fairly serious questions. On April 3rd, I became the president and have begun to implement sort of fundamental changes in our organization. We have, as the report outlines, there were numerous instances of noncompliance in our past that were unacceptable. There was a pattern of withdrawals from the money room by the prior president that was wrong and should not have happened. You've heard that repeated by me, by Mr. Ross, by Mr. Fulton. Shouldn't have happened, and it won't happen in the future. Those occurred because of poor controls, poor governance, and we have implemented sort of immediate changes and are endeavoring to create a culture of integrity, accountability, and responsibility. The Board of Advisors, as we've talked in the past, are people who have put their considerable reputations on the line and sort of attesting to what will happen. While we understand you're not questioning the integrity of the individuals, there is a question around the integrity of the organization, and my role as president to make sure that that level of personal integrity is infused throughout that organization. As it relates to what's going to move forward, if we were to move forward, and I understand this is suitability for the present as opposed to the phase 2, but for our organization going forward, we are going to hire the first-class team of people to fill all those operational roles. They bring that gaming experience, and my job would be to manage that team. Would I tell you which slot machine should go where on the slot floor? Absolutely not. That is not my job. We're going to have somebody whose job it is to do that. My job is to build that organization, make sure they understand, and create a culture of, again, of integrity, accountability, and responsibility, and I believe I can do that. And with that, we appreciate the time you've taken today, fairly lengthy day, and I hope that you will consider favorably our application as suitable.
Thank you, Mr. Grogan. With that, we will conclude this portion of the suitability proceeding. The Commission will deliberate about the matter in private and issue a written decision. The proceeding at this point, however, remains open. If at any point during deliberations the Commission determines that further testimonial or documentary evidence is desirable, it may send notice of such to the applicant and provide instructions as to how to proceed. Further, all applicants, of course, have a continuing duty to provide updated information to the Commission and to the Bureau. It is now July 25th, 2013 at 5:45, and we will adjourn. Thank you all very much.
Thank you.